Where is the time? Only the next week, 3 days are remaining.
My lord, may I be allowed to mention two matters, my lord?
Where is the list? Where is the order?
Yes, Lordship.
Where is it?
Lordship, may I permit to mention it?
Grateful, Lordship.
Lordship, may I be permitted to mention one matter, Lordship? Lordship, it's regarding
next week.
Lordship, an affidavit in opposition is directed to be filed by the respondent in a matter of CO 124/2023. Lordship, today is the last date. But however, Lordship, due to some unforeseen circumstances, we are unable to file. Kindly extend the time, extend the period, Lordship.
It is in the list.
Lordship, today is the last date for filing the affidavit in opposition. Kindly extend the time for filing. That's the period, Lordship.
It is in the list.
No, it is not in the list. It has not come up in the list in this circuit, Lordship. It has not come up in the list.
List code? Yes.
Lordship, actually, that it was directed upon us to affirm and file by 14th, that is today. But Lordship, we are because it is not complete, and also because the petitioner, he is in a bedridden condition. He has some medical condition. That's why he's unable to appear before the department. That's why, Lordship, we're praying for extension of the time so that we can affirm and also file it before the honorable court, Lordship.
Next week,
Lordship, may I permit to mention a matter, Lordship? Claim cases, Lordship.
Grateful, Lordship.
Matter is ready for hearing, Lordship.
Admission. MAC admission is not required. In MAC appeal, admission is not required. That is what you say. The application and reading again, section 5.
My lord.
May I mention what matter?
Yes.
Yes, my lord, I have two matters. Technically, it's 4 matters. One matter, it is one matter contains 3 matters which are analogous in nature. So, my lord, I would like for inclusion in the list, my lord. And one more matter comes up with Bengal excise duty.
Criminal division.
My lord, on the last occasion, Honorable Justice Bibhash Chaudhary have ordered for LCR, but as of till date, they haven't come out, and the state government is harassing me.
So what is the?
And I run a restaurant in Malbazar, my lord.
So what is the urgency?
My lord, the urgency is that, my lord, the Labour Commissioner have filed it in a Shop and Establishment Act, a complaint before the magistrate. And the magistrate, while taking the cognizance, have taken the cognizance of Minimum Wages Act. And like this, they have filed 3 matters against me without informing me or without giving me show cause notice. My lord, on the next week, my lord.
It is in the motion stage or service is complete?
All done, my lord, motion stage. But in the meantime, my lord, they are harassing me. The people from the Labour Commissioner's office is harassing me.
Who is the learned advocate appearing? Where is the mentioning speech?
My lord, he might be in courtroom number 1, my lord. I would call him, he would give the mentioning slip to the court officers.
He is not present now.
Yes, my lord. I believe he's in courtroom number 1, my lord. I would instruct him to come up and give the list, my lord.
Now I have to wait for him.
No, my lord. My lord may pass over it.
There is no matter to pass over.
The problem is, my lord, my grandmother is demented, so that I could not come.
On Tuesday, you come on Tuesday physically, or ask you to remain present physically on Tuesday.
My lord.
Your Lordship, may I be permitted to mention one matter? This is with regard to a release of a vehicle. The urgency is that, Your Lordship, due to the present monsoon, the vehicle is lying in the open space.
Hmm.
So may Your Lordship be permitted to mention inclusion in the list. Matter may be included on the coming Tuesday, Your Lordship.
I wasn't hearing it. Other side.
Services has been completed.
Lordship, yesterday I have listed. Coming to the list today's list, Lordship.
What is the number? What is-
Today 2 PM, Lordship.
What is the number?
CRR 158.
এটা আসুন কালকে দিয়েছে
Lordship, it's my glad mistake, Lordship.
so you have to say that there is a mistake on your part. Give the slip, it will be listed on 17th or 18th, whatever.
Lordship. What are
18th দেবেন
80?
18th 18th এক্সটেনশনে রাখবে
Supplementary list. To be mentioned item number 1, CY 18 of 2024.
আমাকে একটু খবর দিতে হবে
স্যার আমরা যদি ছোট
ঠিক আছে একটু কাউকে বলুন ওই রিমা সরকার ছিল কালকে মুভ করেছে আর আদার সাইডে কি আছে দেখুন তো অ্যাডভোকেটটা ওই যাবে বলি কাকে Mr. Chaudhary, just assist me. You ask Miss Rima Sarkar to appear.
In this matter, my lord?
This
Lordship.
matter was heard yesterday, but
Lordship.
some clarification is necessary. Mayank Bhandari is a practicing advocate of this.
Yes, my lord, he is a member of the bar, yes.
If you could kindly take the pen, just
Lordship,
informing them to appear.
my lord.
Okay. It will pass over, Rakun. Next.
Today's list item number 1, to be mentioned.
My lord, this matter has appeared at the instance of my learned friend appearing for the state, but only for correcting the name of the council for the state.
What will be the names? This matter is appearing under the heading to be mentioned. Mr. Arjun Chaudhary, learned advocate for the state, submits that.
The council will be Mr. Niloy Chakraborty and Shagnik Shikdar, my lord.
Your
Give the
Lordship,
names.
Your Lordship, as the matter has already been mentioned by the state, there is a small mistake in the name of the council for the petitioner as well. Inadvertently, Rajdeep Das name has been reflected, which should be replaced by Jayant Kumar Singh.
At the time of giving names, you give the
No,
names of
no,
learned
Your Lordship, I
advocates.
had distinctly mentioned the state
Do
name.
the AR have any knowledge of what is?
Because Your
because
Lordship,
they are-
there could be a mistake because the item number 4 and 5 was taken analogously and the item number 5 was led by Rajdeep Das.
কি বলো? Names of the learned advocate for the state has been wrongly recorded. The names of so and so needs to be recorded as learned advocates appearing representing the state. Mr. Prajwal Guru, learned advocate for the petitioner, also submits that the name of learned advocate Mr. Rajdeep Das is to be deleted and in his place Mr. Sagnik, what is his name?
Jayant Kumar Singh, I'm mentioning.
Let the names of learned advocates be corrected in the cause title of the order dated 11 June 2024. Mr.
Jayant Kumar Singh.
Be recorded in place of Mr. Rajdeep Das and the names of learned advocates উনি যেটা দেবেন in place of Mr. Aditi Shankar Chakraborty, learned APP, Mr. Niloy Chakraborty learned APP and Mr. Aniruddha Vishwas for the state. Therefore, said order is modified to the above extent. The other portions of the order shall remain unaltered.
But Mr. Nilay Chakraborty with Sagnik Sikdar, not Aniruddha Vishwas. Aniruddha Vishwas was already there, my lord. That has to be.
তাহলে ওই অদিতি শঙ্কর চক্রবর্তী আর অনিরুদ্ধ বিশ্বাসটা ডিলিট করে দেবো।
Yes,
নীলা চক্রবর্তী আর সাগনি।
grateful. Lordship. Grateful.
Yes.
My lordship, my lord. May I please, your lordship. These are service. This is the extension of interim order lastly granted, my lord, 2nd of May of this month. And my lord, let the matter, my lord, be extended and matter to fixed on Thursday, my lord, for hearing. Two matters
Yes, your
here and
lordship,
analogous
the matter
hearing.
may be fixed on Thursday for hearing, your lordship.
And in the meantime, extension. Initially, order has been passed, interim order has been passed by my lord justice. Vivek Chaudhary, my lord, on
Item number 2 আছে, 3 আছে।
21st December 2022.
3 তে এসে নেই। Interim orderটা নেই।
সার্ভিসটা দিলাম। বলে দিস।
State. Will the matter be heard today?
No, lord, because the matter appeared before lordship extension interim order. The lordship can fix the matter on Thursday, my lord.
Thursday it will not be possible.
Then Friday,
That is
Friday,
last-
Friday, next Friday.
Huh?
Last-
Friday?
Friday.
No.
No, they haven't. No. Tuesday and Wednesday, my lord, there are 4 matters fixed before court number 11.
So here the next circuit then. Tran 3 of 2024. This is an application for extension of the interim order granted earlier on 21st December 2022. Mr. Ajoy Devnath, learned advocate for the petitioner, seeks for extension of the interim order. Both the learned advocates for the state as well as OP number 2 complainant opposes such prayer. Till 31st May. The interim order granted earlier on 21st December 2022 is reimposed and extended for a period of 4 weeks or until further order, whichever is earlier. Let the matter be placed. 4 weeks. 4 weeks. Because of whichever party shall be at liberty to pray for extension of the order, matter to be placed before the next available circuit bench. Tran 3 of 2024 disposed of.
Grateful, my lord. And deeply obliged.
এটার সাথে আরেকটা ম্যাটার আছে না?
I'm grateful. That is no extension. Well, let two matter hard analogously because it's coming from the same FIR.
Next, sir.
Get from it.
Next.
Item five.
No, 4.
My lord, my lord, 4, I am for the petitioner, my lord. My lord, I mentioned this matter yesterday for extension of interim order. My lord, in this matter, the initial interim order was passed on 22nd of April by my lord Justice Shubhra Ghosh, and it was thereafter extended on 22nd of May, my lord. The order is still effective till 17th, my lord, that's Monday. So my lord may be pleased to extend the interim order. My lord.
What is the case?
My lord, it's a case for quashing of a FIR, my lord. If my lord is pleased, my lord, the matter can be heard today also, my lord. I am ready for that.
You have the CD.
Oh, Mr. Chakraborty is in the matter, but since he is not there, he asked me to appear just for the explanation purpose.
Mr.
Then, my lord, subject to my lord, can it be
Learned
placed?
advocate for the petitioner seeks for extension of the interim order. Mr. Arjun Chaudhary, learned advocate for the state, informs the court that the case diary is not available. The interim order granted earlier on 22nd April 2024 is extended for a period of 4 weeks or until further order, whichever is earlier, let the matter be placed before the next available session.
The can be disposed of.
There is no CRAN. Interim order is valid.
Oh,
It is valid. Till 17th June, it is valid.
I'm grateful.
I'm grateful, my lord.
Yes.
Item number 5, Your Lordship, I am for the present petition, for the appellant in this present case. Your Lordship, this present appeal was preferred against the conviction, judgment of conviction granted against this present appellant in special POCSO case number 15 of 2022, passed by the learned additional district and session judge Kalem, Your Lordship. The said appellant was convicted under section 354B of the Indian Penal Code, section 67B of the Information Technology Act 2000, and section 12 of the Protection of Children from Sexual Offense Act 2012, Your Lordship. The present appellant was convicted on 12th of April 2024, and since then he is in custody, Your Lordship.
Yes.
Your Lordship, in this matter, my grounds for this present appeal is that various facts has been overlooked by the learned court below, and there are certain law points that needs to be clarified before this honorable court with regard to filing of evidences, electronic evidences, Your Lordship, because there are already a prerequisite provisional guidelines laid down in the Indian Evidence Act, which the prosecution has, in my view, not complied with. They have not complied with the certain
What is
provisions
that?
that. Lordship,
What has not been compliant, and what is the
Your Lordship, this entire case is based on WhatsApp, Instagram messages, Your Lordship, messages in a social networking site. Now, with this regard, the prosecution has obtained certain documents from the Facebook authorities as well as from the Vodafone Airtel companies, but the investigating officer of this present case has failed to produce the certificate from the proper authority, Your Lordship. He has most of the electronic evidence that was obtained from another sources. The investigating officer has himself signed in the state certificate, which proves to be which could be a little skeptical, because the state electronic evidences were obtained from the Facebook authorities and from the Airtel authorities, the Vodafone authorities as well. But the IO himself has sign on the said certificate which was produced before this court, before the learned court below, and which was admitted. And Your Lordship, there are other facts that needs to be elaborated. If the LCR is called for, I could be able to place that facts, because the lower court,
For me, where is the evidence of the IO?
Your Lordship, I have not annexed
Where is the discussion of the evidence of the IO? What is the PW number of the IO?
Your Lordship, it is observed in page number. Page number 54, Your Lordship, the certificate has been mentioned, wherein the 3 or 4 screenshots were obtained from the laptop of the victim girl, which was in possession of the father of the victim girl. Though the screenshots were, the certificate was signed by the father, I'm not pressing that matter, but the other evidences, electronic evidences, such as the call records, the call detail records, the customer acquisition report was signed by the IO himself, but which was obtained from another source, Your Lordship. And the one major fact is, Your Lordship, the fact that has been overlooked is the girl in her statement herself has admitted to the fact that she had depicted herself to be a girl of 19 years age. Your Lordship, if this LCR is called for, and if Your Lordship would go through the statements given by the victim girl herself, she has clearly stated in her statement that she had depicted herself as to be a 19 years old girl, Your Lordship. And allegedly, this accused person was not aware of the age of the girl, because this entire case is based on messages that was exchanged during through Instagram platform, Your Lordship. And one more fact, Your Lordship, the father of the victim girl had given 4 screenshots of 4 different accounts, Your Lordship, and the prosecution has just went into depth with regard to only three of the accounts. One of the accounts has been clearly mentioned that it was linked to account at Sweden, and the prosecution totally left the said account untouched, Your Lordship. Whereas the father of the victim girl has clearly mentioned in his written complaint that these 4 accounts were involved in such in this alleged offense, Your Lordship.
Victim has been served. Notice of appeal has been sent to the victim.
No, Your Lordship, this is the first time the matter is appearing for admission. Your Lordship, may the appeal be admitted, Your Lordship. In the meantime, we'll serve the notices to the
Foxtrot basically আছে Foxtrot আছে কিনা দেখুন 376 এর কি ছিল
Your Lordship, this facts I've mentioned is also mentioned in page number 7, the PW8, who is the IO of this present case.
victim is to be notified.
Your Lordship, as the matter was not yet admitted, and this is the first time this matter is appearing, Your Lordship.
At this stage of admission also, Probably there is a problem. Ah. The matter that was heard yesterday,
Madam.
certain clarifications are required.
Madam.
Because Mr. Mayank has placed a decision of Allahabad High Court,
Madam.
where the decision of the Honorable Supreme Court was referred to.
Madam.
You remember he referred to a decision of Allahabad High Court. He said that the paragraph 14 says so that only the tax is to be deducted,
Madam.
not the
Yes, madam.
provident fund.
Madam.
But the judgment of the Supreme Court is otherwise. I need a clarification on that. Whether the provident fund is to be deducted from the. That's why you just inform the other side.
But I just tried to establish contact with Mayank Bhandari, but he is still on his way to court, Lord. It is not-
Okay, whenever he comes
Fine.
at 2 p.m., I will take it up.
Fine.
Both of you remain present. Huh? Ah. He is old man. Mr. Chaudhary, in a conviction of POXO at the stage of admission, where the victim has to be given a notice.
Yes, yes.
Give a notice then. Ashok? This appeal is referred against the judgment, an order dated 12th April 2024, passed by learned Additional Sessions Judge, Second Court POXO, Kalimpong, in connection with special POXO case number 15 of 2022, arising out of Cyber Crime Police Station, Kalimpong PS case number 9 of 2022, convicting the appellant for offence punishable under section 354D of the Indian Penal Code, section 12 of the POXO Act 2012, and section 67B of the Information Technology Act 2000. Full stop. Mr. Jalpaiguri learned advocate for the appellant submits that the entire case is based on the electronic evidence which has not been proved in accordance with law. Learned appellant is right to serve notice upon the victim. Let the matter appear the next week of the before placed before the next available circuit bench. Serve notice to the victim.
Yes, Lord, I am for the state. Lord, this affidavit of service. Service complete.
What is it?
Lord, this is an application under section 407 of CRPC for transfer of criminal proceeding from Alipurduar district to Jalpaiguri district.
From Jalpaiguri to?
From Alipurduar to Jalpaiguri. The whole alleged incident was occurred within the jurisdiction of Jalpaiguri district, which is an Bhaktinagar police station. And after the last occurrence, alleged occurrence was took place on 2nd of October 2023, and the FIR was lodged in 13th March 2024, my lord, at Kumargram police station. My lord, the petitioners are the petitioner number 1 is aged person, and he is suffering from various diseases. I have annexed his medical document as in page number 17, my lord. He is going through some problem of his
No.
mental and neuro problems. my lord.
There are other provisions under the CRPC. Why the entire case is to be transferred.
Lordship, may I?
Mr.
Okay.
Lordship, I appear for the petition.
You are for the?
Petitioner.
Petitioner.
Ah,
My lord, the entire course of action of this present case arose beyond the jurisdiction of the present place where the case is proceeding. Though, my lord, it is very well settled that the jurisdiction of a criminal case that way doesn't matter. So it swings in both ways, my lord. It swings against me and it also swings in my favor. So all the cause of action, evidence, witnesses are within the jurisdiction of Jalpaiguri court. So it will be also prudent for the petitioner de facto to get a case dealt in Jalpaiguri, and since the petitioner is a aged senior citizen, traveling to Jalpaiguri from Kuch Bihar would be a problem for him from others. The evidence would be same, the punishment would be same if he is convicted. And if he is acquitted, the same acquittal will be handed down by the courts either in Kuch Bihar or in Alipurduar and Jalpaiguri. So that is why we pray indulgence from your lordship that the old man may be given some reprieve when he faces the trial.
okay. Yes.
Now, my lord, as my learned friends say, but jurisdiction in criminal case not only depends on the as per the submission he has raised. First of all, the lady, she was subjected to torture in her matrimonial home. She went back to her parental home and she lodges a complaint. Look, this is a settled law that after a lady goes back to her parental house, she can lodge the complaint there also under 498A of the IPC. So, look, there is no dispute or no problem with regard to the jurisdiction of the case. But second thing, they are saying that the witnesses, they reside in Siliguri, it will be difficult for the witnesses to come. Look, that is for the state and prosecution to decide how to bring the witnesses. It is not for the accused to say, my lord, that the witness will be facing difficulty. My lord, we are there for to look after the witnesses. So, my lord, at this and moreover, my lord, since it is also a settled law that the convenience of the wife has to be looked into. My lord, it cannot be discarded in its entirety. So, my lord, unless the wife comes before this honorable court and gives makes a submission, opens a stand, Lord, I think, Lord, no order should be passed in this application, Lord. Lord, let the victim come. Let the
Victim has been charged, my lord.
No,
Has
it is-
been charged. If she chooses not to come, it is also not for the state to plead on behalf of the wife. Why the state is taking the matter? She has been served and she chooses not to come.
Okay. Okay.
We bring her from her house.
Affidavit of service filed on behalf of the petitioner is taken on record. This is an application under section 407 of the Code of Criminal Procedure, hereinafter referred to as the raid with section 482 of the Code of Criminal Procedure. একবারই বলবেন section 407 raid with section 482 of the Code of Criminal, hereinafter referred to as the code for transfer of criminal proceeding being GR case number 443 of 2024 within bracket arising out of Kumargram Police Station case number 55 of 2024 dated 13th March 2024 under section 498A of the Indian Penal Code, in short IPC, and sections 3 and 4 of Dowry Prohibitions Act, comma, pending before learned Chief Judicial Magistrate, Alipur Duar. आगे ट्रांसफर बोल रहा हूँ, ट्रांसफर बोल रहा हूँ, पेंडिंग बिफोर टू जलपाईगुड़ी. Mr. Sudipto Mojumdar, learned senior advocate through virtual mode, appearing through virtual mode over the cycle, submits that the petitioner number 1 is a aged person. Stop. Furthermore, the witnesses are all residents of private witnesses are all residents of Jalpaiguri, where the cause of action arose. Therefore, for convenience of all the parties, it would be appropriate to transfer the proceedings from learned Chief Judicial Magistrate Alipur Duar to the criminal court at Jalpaiguri. He seeks for appropriate order. On the contrary, Mr. Arjun Chaudhary, learned advocate appearing for the state, submits that the jurisdiction of the court is not in dispute. So far as the so far as securing presence of the witnesses are concerned, secure the attendance of the witnesses are concerned, that squarely lies with the prosecution. Therefore, the grounds taken for transfer of the proceedings to Jalpaiguri fall short of merit. He seeks for dismissal of the application. The the petitioner has made twofold grounds for transfer of the criminal proceedings pending before the court at Jalpaiguri. Firstly, on the ground of ill health of petition number 1, ill health and age.
On not only 1 minute, one.
And
1, 2, and 4 minutes.
Attendance of the witnesses from Jalpaiguri to Alipurduar. It is needless to mention that the appearance of an accused before the court can be dispensed with under other provisions of the Criminal Procedure Code. So far as the attendance of witness is concerned, this court finds substance in submission of Mr. Chaudhary, learned advocate for the state, that securing of attendance of the witness lies with the prosecution.
Lordship, may I
Your-
once,
Above, the
Lordship, one liberty, my lord.
the ground saying yes, Mr. Holy.
My lord, we are not on the ground of exemption of appearance of the accused, my lord. My lord is absolutely correct when your lordship, there is fallen from your lordship that there are other modes in CRPC. Thereby, my lord indicates 205 and 317. But my lord, there the accused runs the period of evidence being recorded in his absence. But if the case is transferred to a convenient place, convenient to both of them, a young lady on the other side and an octogenarian on the other side, the evidence will be recorded in presence of the accused as the criminal justice requires, and that is the paramount. That is our prayer, my lord.
Whenever that will, the trial court will decide how the
But
evidence will be recorded
we
in
have
whose
not
presence
gone
they
under
will.
205.
No, this cannot be decided right now in this application.
Right, my lord.
In view of the above, the grounds fall short of merit. According, the application stands dismissed. Okay,
That's true, my lord.
yes. Thank you, Mr.
No, sir.
এই সাহেব একটু দেখুন না, ওনাকে একটু বলুন না, এই স্ল্যাবটা উঠছে নামছে না, এটা তুলে রাখুন ওপরে। Seven.
Yeah, please, your lordship.
Yes.
Lordship, this is an application under 482 dated with 227 of the Constitution. My client, Shunil Modak, signed the affidavit, and the complaint which against I raised the voice is at annexure P1 at page 16. The story in nutshell the petitioner has took a loan of 1,18,500 rupees in the year 2013 from the second opposite party, Cholamandalam Investment Company, which is a private company, and their interest rate is about 27.96%. And after few months, after few EMIs has been paid, due to his property and due to his loss of business, he was failed to pay the EMIs. And accordingly, the company, the respondent number 2 hearing, has took out his took up their that particular four-wheeler, which was taken on loan.
Yes, continue.
Lordship, the loan was taken in Jalpaiguri from the offices at Shiliguri. All the agreements were done in Jalpaiguri and Shiliguri region. But unfortunately, after lapse of 10 years, on the some concocted stories, the complaint is filed at Metropolitan Magistrate at Calcutta, commonly known as Financial Court. Lordship may kindly come to paragraph number 9, page 17. I have also annexed the certified copy of the complaint and all the orders. I am harping upon only 2 points today, Lordship. The first is, may I read paragraph 9, Lordship? Then complainant, after waiting for a reasonable period, that is 10 years, on his own interest, tried to contact with the accused number 1 several times, but he could not. Then the complainant contacted with accused number 2, but they are even denied to talk to the complainant and abuse the complainant in ugly language. This has happened after 3rd January 23, which is mentioned at page 7, which company claimed that a notice has been given. Now, Lordship may kindly come to page 3 of my petition at para 2, wherein I have specifically stated that the complainant number 2, that is the wife of the present petitioner, has died before a decade ago.
Page 3.
Page 3 of my application, Lordship. It is at paragraph number 2.
What is paragraph number 2?
That the accused number 2 stated in the above mentioned complaint being such and such, pending before the learned 13th Court Metropolitan Magistrate, Calcutta, West Bengal, was the wife of the present petitioner and died more than a decade ago.
She is alive.
She died
When?
about 10 years back.
So what is the
So question of raising her voice or contact her is not at all possible even after 3rd of January 23, which is mentioned in paragraph 7 of their complaint only.
But this should be filed before the principal bench, no? Should be taken up by the principal bench.
Lordship, I am staying in Jalpaiguri.
You can stay. The case has been initiated at Calcutta.
But Lordship, all the
No.
agreement and offices are belong to this region only.
So move before the principal bench. Hmm. বিষয় ওটা ট্রান্সফার করে কি করে? ট্রান্সফার কি করে? এটা প্রিন্সিপাল বেঞ্চে
Lordship, shall I withdraw the matter and file it afresh? It's from the legal aid.
legal aid.
I'm appointed by legal aid.
But then the processes has been issued by the magistrate at Calcutta. Cases filed at Calcutta. Withdraw, you can withdraw.
Lordship, my understanding was. Lordship, my senior told me
Can this matter be
transferred to the principal bench.
Because this is legal aid matter, so once again filing will be impossible for him. Lordship was rightly pointed out that the jurisdiction of our circuit bench consists of certain districts. The cause of action of this case, as I heard from behind, is beyond the jurisdiction of this circuit. So if the matter can
Processes
be
have been issued by the Metropolitan Magistrate.
so it is that district is not under the purview of our circuit bench. So obviously it will be before the principal, but if the matter can be sent there. So filing, costing and other things, my brother can move
Gotcha.
there. Grateful, Lordship.
It is. Acha, this application is filed under section 482 of the Code of Criminal Procedure for quashing of proceedings being numbers being CS case number 10217 of 2023 pending before learned Metropolitan Magistrate 13th Court, Calcutta. জেনে নিন এটা ট্রান্সফার হবে নাকি রিফাইল করতে হবে, জেনে নিন। ট্রান্সফার ও রিফাইল আমার নাম্বার পড়বে তো, কে বলতে পারবেন? একে ডাকুন ফাইলিং এর, একে ডাকুন ফাইলিং বা রেজিস্ট্রারকে ডাকুন, রেজিস্ট্রারকে ডাকুন, একটু জেনে নিন। পাস ওভার রাখুন তো, যদি হয় তাহলে ট্রান্সফার করবেন। ট্রান্সফার হয়ে যাবে মনে হচ্ছে, রিফাইল করতে হয় না। এ নিচ্ছিলাম না, রিট পিটিশন নিচ্ছিলাম, ওখান থেকে তো অনেকটা এখানে চলে আসতাম। চলুন রিট পিটিশন নিচ্ছিলাম তখন ওটা এটা তো জলপাইগুড়ির নাম্বার, এখন তো ওখানে সিআরআর নাম্বার 125 অন্য হবে। ট্রান্সফার প্লেস বিফোর দি প্রিন্সিপাল বেঞ্চ। ওটা ফাইন্ডিং আমি জাস্ট জেনে নিচ্ছি। চেঞ্জ হয় না? বলছি যে এখানকার একটা এখানে যেটা ফাইল হয়েছে জুরিসডিকশনটা প্রিন্সিপাল বেঞ্চের, আমি অর্ডার করে ট্রান্সফার করলে ওখানে তো আবার একটা নাম্বার পড়বে, এটা রিফাইলিং হবে তো ওখানে,
এখানটায়
এখান থেকে চলে যাবে প্রিন্সিপাল বেঞ্চ,
আলাদা রিফাইলিং হবে, হ্যাঁ
একটা ফাইলিং নাম্বার পড়বে না? ঠিক আছে ঠিক আছে, চলো কি বললাম? In view of the above, let the matter be placed before the principal bench of this honorable court, having appropriate determination. It has been sent.
Lordship.
My lord, in item 8, my lord, I am praying that the matter be listed on Wednesday. My lord, I could not get enough time to prepare myself, my lord, so many hearing matters today. But I have challenged the proceedings, my lord. 498.
4B. Charge sheet submitted?
Yes.
সিস্টেমটা মডিফাইড হয়ে আছে।
হ্যাঁ ওই নাম্বার থাকবে, ট্রান্সফার করতে কোনো অসুবিধা নেই তো?
এখান থেকে আপনি ট্রান্সফার করে দিচ্ছেন ভাই,
হ্যাঁ
কোনো অসুবিধা নেই।
ওখানে কোনো রিনাম্বার
রিলিজ করে দিচ্ছেন,
হ্যাঁ বিশেষ করে ওখানে প্লেস করতে পারবে, ওখানে রিনাম্বার হবে না তো?
হচ্ছে অন্য নাম্বার।
ঠিক আছে ওকে। What is the ground?
My lord, so far I can recollect, my lord, this is with respect to, my lord, 1306 case. Now, my lord, the mother of the principal accused and the brother of the principal accused is before your lordship. My lord, the marriage itself was void. So on that ground, my lord, this 498 and this other ancillary provisions, my lord, that will not be attracted.
But that will be decided by the court at the time of framing of the charge, whether
Lord.
306 will lie or
My lord,
304.
allow me 2 days time. I will satisfy your lordship on that point, my lord.
Mr. Arjun Chaudhary, learned advocate for the petitioner, seeks accommodation. Let the matter appear on 19th, no, Wednesday 19th. 19th.
Grateful, my lord.
Oh, sorry, the Atma matter.
Not in 9, I am for the petition.
Yes. Yes.
May I start, Milord? Milord, on the earlier occasion, Milord, I was impressing your lordship with respect to how the trial was going on. And Milord, my contention was that the defense had received all opportunities, Milord, to place their case. So, Milord, the last date, Milord, which was 22nd of February 2024, on which date, Milord, the learned public, that is page number 65, Milord.
Lord, we have a legible copy of page 65.
Ah.
As your lordship had.
Evidence copy গুলো চেয়েছিল। So, Milord,
Yes.
yes. So, Milord, the learned PP in charge submitted before that court, before the trial court, that despite giving the documents earlier on the earlier occasion, he has again supplied those documents. So, Milord, there is from this submission and from the observation of the learned trial court, it is very specific and clear that 207 was already complied with, but showing his good gesture, Milord, he has again supplied the copy. So, Milord, there is no dispute with respect to supply of copies at later stage. Milord. It was already done on the earlier occasion.
Yes.
Okay.
Yes.
Now, Milord, the earlier date, as I pointed out, was 22nd of February 2024. And Milord, the next date, page 66, that is almost after a month, Milord, the next date was fixed, 18th of March 2024. Milord has found me? Yes. So, Milord, more than almost a month time was given to them. And on the said date, 18th of March, Milord, the investigating officer was supposed to be examined. And Milord, further cross-examination of PW 22, who is the investigating officer. So, Milord, the investigating officer was cross-examined again on part.
IO was first examined on which date?
On 22nd of February, my lord.
Ah.
Since it was already 7:05 p.m., Milord, so it was deferred. On 18th of March, he was again cross-examined in part.
Yes.
Milord, we'll find the next date then. That is the very next after 19th of March. The very next day, Milord, the IO was again called. he was again examined, cross-examined in part. On 19th also, he was cross-examined in part, my lord, will find that. PW 22 is put on dock and cross-examined in part and discharged. Yes. Next date is 20th of March. My lord, page 69. My lord, on that date, the cross-examination of the investigating officer was completed. So, my lord, for 3 consecutive dates, my lord, the IO was partly cross-examined. And my lord, ample opportunity, my lord, the defense received to cross-examine the investigating officer.
Yes.
Now, my lord, on that date, on 20th of March, after the investigating officer was cross-examined, my lord, that 311 application which was filed earlier, my lord, was taken up for hearing, which is under challenge before your lordship now. My lord, the learned trial court, after hearing the public prosecutor, after hearing the defense counsel, my lord, comes to a conclusion that the defense had got enough opportunity. They have placed sufficient questions to the witnesses, and recalling those witnesses at this stage will amount to filling up lacuna in the defense case, my lord. So that is not permissible as per the settled proposition of law set by the Honorable Supreme Court, and as such the application was rejected. Lord, one contention.
Yes.
Yes, Lord, one contention the defense had raised during the course of hearing of the 311 petition, that the prosecution filed one application at the earlier stage on 3rd of January for recalling of 4 witnesses. The court allowed that. But when we are trying to recall some witnesses, the court is rejecting our application on frivolous reasons and observations. So, my lord, it is categorically clear that when that application was filed by the prosecution, the defense did not raise any objection. It was heard in presence of the parties. The defense did not raise any objection, and as such, the court allowed it. And when this application was heard, the public prosecutor raised objection with sufficient reasons. And we are definitely calling the witnesses at this stage amounts to filling up the lacuna, my lord, which is not permissible. My lord, no party, not even the prosecution, nor the defense, no party should be allowed to fill up the lacuna in the case which shall amount to a de novo trial or a retrial. My lord, that is not permissible. A new case cannot be made out at this stage. So, my lord, the learned trial court has rightly rejected the application, and thereafter, my lord, 313 happened. My lord, they called to defense witnesses. Even the learned magistrate, my lord, who conducted the 164 state examination of the witnesses, my lord, he was also called as a defense witness, defense witness number 2. And after the defense witness were completed, prosecution completed its argument. My lord, today the defense argument is going on in the learned trial court. And my lord, now at this stage, my lord, defense witness is already completed. Defense argument is going on today, my lord. Now, at this stage, my lord, there is no ground to, my lord, allow this application. There is no scope to allow this application. This application has already become infructuous. First. Second thing, my lord, my learned friend has cited some judgments. My lord, I will distinguish those judgments. As those judgments are, my lord, factually and even on the point of law, my lord, they do not apply to the present case. Bashira. Lord, my learned friend has relied on a judgment of the Supreme Court, Bashira versus State of Uttar Pradesh, my lord. Lord, in that case, Lord, what happened? Lord, one amicus curiae was appointed by the learned trial court to represent the accused. Lord, on the same date, when he was appointed, Lord, charge was framed, and the key material witness was the sole eyewitness, Lord, he was also examined on the same date. So, Lord, the defense went before the Supreme Court and said that the procedure which was adopted by the learned trial court is dehodes the rules and principle of natural justice has been violated. So, the Honorable Supreme Court has considered that and Lord remanded the matter back to the trial court. But Lord, in the present case, Lord, I have substantiated before your Lordship that the defense had got enough opportunity to cross-examine all the witnesses, place their case before the learned trial court. And my lord, as my learned friend has repeatedly said that within a period of 16 days, my lord, I have shown your lordship from 3rd of January till my lord 2022 or 23 of 3rd of March, my lord. So almost three months time was given for all the prosecution witnesses to be completed. So my lord, there is no hurried trial in this case. Well, a hurried trial is something which happened in Bashira, but not in the instant case, my lord. So Bashira is distinguishable on facts. Next, my lord, another judgment, that is Naveen versus State of Madhya Pradesh. So, my lord, in Naveen also,
Yes.
my lord, in Naveen versus State of Madhya Pradesh, my lord, within a period of 23 days, my lord, the trial was completed and death sentence was awarded to the accused person. My lord, from the date of filing of the charge sheet, within a period of 13 days, my lord, entire thing happened. And total period is 23 days. So, we'll have 10 days for charge sheet and next 13 days for trial. So, that is called hurried trial, my lord. But in the present case, Lordship knows that even today the defense argument is going on. My lord, the case started somewhere in the month of June, July of 2023. Investigation happened, charge sheet filed, copy served. Then, my lord, charges framed, trial started. Everything happened in its proper way, my lord. So, my lord, Naveen is also distinguishable, my lord, in facts. Yes, my lord, another judgment, my lord, a Madras High Court judgment, K. Ravichandran versus Inspector of Police. My lord, in K. Ravichandran, the Madras High Court has thought on 2 points, my lord. The first is no party should be stopped from correcting errors, and the essentiality of fair trial. So, my lord, that is known to everyone, my lord. Even we are not disputing, my lord, that fair trial should happen to everyone. For every person in a litigation, my lord, there should be a fair trial. No one is denying that. Second is no party should be stopped from correcting errors. Definitely, my lord. If it is a genuine error, then no party should be stopped from correcting it. But if under the garb of correcting errors, my lord, if I try to bring a new case, if I try to make a de novo trial, my lord, that is not permissible under the law, my lord.
Okay.
Lord, I shall be referring to 3 judgments.
And one other judgment he has referred of
Hello?
Anokhi Lal.
Anokhi Lal. Achha. One.
What is the paragraphs you have referred of? 15 to 18.
Not page
15 to 18.
paragraph 14 to 18.
14 to
Oh,
18.
Similarly, in Anokhi Lal also, in para 14, it is said in the present case, the amicus curiae was appointed on 19th February 2013. And on the same date, the council was called upon to defend the accused at the stage of framing of charges. One can say with certainty that the amicus curiae did not have sufficient time to go through even the basic documents, not same as Bashira. Same.
Which paragraph?
This is para 14, Milord, page number 41. Trial was completed in 15 days also.
On the date of framing of the charge, he was asked to cross-examine the witness.
Yes. And Milord, trial was completed in 15 days in that case also. Anokhi Lal.
Yes. Yes.
Lord, the very first judgment, my lord, I have given is of the Supreme Court, State of Haryana versus Ram Meher, my lord. My lord will find the relevant portion in page number 12. Lord, page number 12, para 37, the last two lines in the bottom, my lord.
Yes.
Yes. Lord, it says there is a definite purpose in referring to the aforesaid authorities. We are absolutely conscious about the factual matrix in the said cases. The observations were made in context where examination in chief was deferred for quite a long time and the procrastination ruled as a monarch. Our reference to the said authority should not be construed to mean that section 311 CRPC should not be allowed to have its full play, but a prominent one. The courts cannot ignore the factual score. Recalling of witnesses as envisaged under the said statutory provision on the grounds that accused persons are in custody, the prosecution was allowed to recall some of its witnesses earlier. The counsel was ill and magnanimity commands fairness should be shown. We are inclined to think are not acceptable in obtaining factual metrics. The decisions which have used the words that the court should be magnanimous, needless to give special emphasis, did not mean to convey individual generosity or magnanimity which is founded on any kind of fanciful notion. It has to be applied on the basis of judicially established and accepted principles. The approach may be liberal, but that does not necessarily mean the liberal approach shall be the rule and all other parameters shall become exceptions. Recall of some of the witnesses by the prosecution at one point of time can never be a ground to entertain a petition by the defense, though no acceptable ground is made out. It is not an arithmetical distribution. This kind of reasoning can be dangerous. In the case at hand, the prosecution had examined all the witnesses. The statements of all the accused persons, that is 148 in number, had been recorded under section 313 CRPC. The defense had examined 15 witnesses. The foundation for recall, as is evincible from the applications file, does not even remotely make out a case that such recalling is necessary for just decision of the case or to arrive at the truth. The singular ground which prominently comes to surface is that the earlier counsel who was engaged by the defense had not put some questions and failed to put some questions and give certain suggestions. It has come on record that number of lawyers were engaged by the defense. The accused person had engaged counsel of their choice. In such a situation, recalling of witnesses indubitably cannot form the foundation. If it is accepted as a ground, there would be possibility of a retrial. There may be an occasion when such a ground may weigh with the court, but definitely the instant case does not arouse the judicial conscience within the established norms of section 311 CRPC for exercise of such jurisdiction. It is noticeable that the High Court has been persuaded by the submission that recalling of witnesses and their cross-examination would not take much time, and that part the cross-examination could be restricted to certain aspects. In this regard, we are obliged to observe that the High Court has failed to appreciate that the witnesses have been sought to be recalled for further cross-examination to elicit certain facts or establishing certain discrepancies and also to give certain suggestions. We are disposed to think that this kind of plea in a case of this nature and at this stage could not have been allowed to be entertained. Next para, kindly. At this juncture, we think it apt to state that the exercise of power under section 311 CRPC can be sought to be invoked either by the prosecution or by the accused person or by the court itself. The High Court has been moved by the ground that the accused persons are in custody and the concept of speedy trial is not nullified and no prejudice is caused, and therefore the principle of magnanimity should apply. Suffice it to say, a criminal trial does not singularly centers around the accused. In it, there is involvement of the prosecution, the victim, and the victim represents the collective. The cry of the collective may not be uttered in decibels, which is physically audible in the court premises, but the court has to remain sensitive to such silent cries, and the agonies for the society seeks justice. Therefore, a balance has to be struck. We have already explained the use of the words magnanimous approach and how it should be understood. Regard being had to the concept of balance, and weighing the factual score on the scale of balance, we are of the convinced opinion that the High Court has fallen into absolute error in axing the order passed by the learned trial judge. If we allow ourselves to say, when the concept of fair trial is limitlessly stretched, having no boundaries, the orders like the present one may fall in the arena of sanctuary of errors. Hence, we reiterate the necessity of doctrine of balance. And my lord, in view of these observations, my lord, the order of the High Court was set aside. My lord will find, my lord, the next judgment, so that is a small one, Gujarat High Court judgment, and very recent one, my lord, 2022. My lord, paragraph 5, page number 4.
Yes, yes.
It says a decision of the Supreme Court relied on the learned advocate by the petitioner in the case of Mohanlal Shamji Soni versus Union of India, reported in so and so, is of no help to him, as Supreme Court has said that Section 311 empowers the court to invoke its power in this regard at any stage until the judgment is pronounced, but at the same time, it has also been said that the power must be used judiciously and not capriciously or arbitrarily. Since, as observed by the Sessions Court in para 3 of the impugned order, the detailed cross-examination of each witnesses running into 2 to 7 page is made, nothing was left out to be asked to the witness. At any rate, the application given by the petitioner accused is also lacking in detail that which of those important questions are left out to be asked to the witness on recall. Not only that, as observed by the learned judge, thereafter also prosecution witness number 9 to 13 have also been examined and the case is on the verge of completion. Another decision of the Bombay High Court relied on by the learned advocate for the petitioner, rendered in criminal application number so and so, decided on 22nd 4th 2014, is on the same principles as referred to in the aforesaid Supreme Court decision. However, as observed by the Bombay High Court relying on a decision of the Supreme Court in the case of Natasha Singh versus CBI, reported in so and so, for a proposition that the dominant consideration to exercise jurisdiction under Section 311 of the Code is whether calling of a witness was necessary for the just decision of a case. However, petitioner has failed to show that without recalling the witnesses, the court is unable to deliver the judgment. Not only that, what is left out to be asked to the said witness is also not stated in the application, praying for recalling of those 3 witnesses. Because this is bit factually different, because the defense in the trial court had given a list of questions, but my lord, that does not absolve him from the observations and the settled propositions of law set by the Supreme Court of India. And my lord, finally, my lord, our High Court's judgment, my lord, passed by His Lordship, my lord, Justice Shivkant Prasad, my lord, as His Lordship then was.
Yes.
My lord, we come to paragraph 12, page number 3, my lord. My lord, found it?
Yes.
It is settled position that to punish an offender in the event of commission of an offense is to subserve a social need. Society cannot afford to have a criminal escape his liability, since that would bring about a state of social pollution which is neither desired nor warranted. In a cited decision reference of case in Vijay Kumar versus State of Uttar Pradesh and another reported in so and so was made, wherein the concept underlying the provision of Section 311 of the Code was considered in the following lines at para 15. It says para 15, though Section 311 confers vast discretion upon the court and is expressed in the widest possible terms, the discretionary power under the said section can be invoked only for the ends of justice. Discretionary power should be exercised consistently with the provisions of CRPC and the principles of criminal law. The discretionary power conferred under Section 311 has to be exercised judicially for reasons stated by the court and not arbitrarily or capriciously. Next, my lord, para 15. In the middle part, in the state, my lord, another judgment of the Supreme Court was referred to, my lord. In the state, NCT of Delhi versus Shiv Kumar Yadav and another reported in so and so, it was held, certainly recall could be permitted if essential for the just decision. but not on such consideration as has been adopted in the present case. Mere observation that recall was necessary for ensuring fair trial is not enough unless there are tangible reasons to show how the fair trial suffered without recall. Recall is not a matter of course, and discretion given to the court has to be exercised judiciously to prevent failure of justice and not arbitrarily. While the party is even permitted to correct its bona fide error, may be entitled to further opportunity even when such opportunity may be sought without any fault on the part of the opposite party. Plea for recall for advancing justice has to be bona fide and has to be balanced carefully with the other relevant considerations, including all called for hardship to the witnesses and uncalled for delay in 17 trial. Having regard to these considerations, there is no ground to justify the recall of witnesses already examined. Milord may come to para 18, next page then. Milord. The middle part, Milord, will find. Para 18.
বন্ধ করে দিন না, হ্যাঁ বন্ধ করুন, বন্ধ করুন, নাহলে ফ্ল্যাপটা যেটা ঘুরছে ওটা বন্ধ করুন, উপরে রাখুন। Yes,
Milord, the petition so made before the trial court was bereft of explanation for recall, as prayed by the prosecution, and I find that the learned trial court has rightly concluded in his finding that there is no legal requirement to recall of the witness. The allegation in the revisional application leveled against the conducting public prosecutor in charge has not been substantiated by the petitioner in the given facts of the case. Since the petitioner was not under any external pressure, who deposed in unequivocal term during cross-examination that the loan was sanctioned in his favor, an amount of loan was credited to his account for the purchase of machineries. Since the application under section 311 of the code was filed by the public prosecutor in charge for recall of the PW1, the conduct of the public prosecutor cannot be faulted with in order to take a ground in this revisional application. The order impugned as it reflects therefrom that the learned PP in charge and learned advocate for the accused were heard at length. So it cannot be said that the learned PP in charge allowed the application to be rejected by absenting from the court and by engaging himself in another court on the day of hearing. The subsequent dates for evidence of CSW 2, 3, 4, and 5 were scheduled by the trial judge, but Mr. Bhaskar Banerjee, newly appointed PP in charge, addressed the court on 15 December 2016 that CD was not handed over to him by the erstwhile PP in charge, namely Najibul Islam, since deceased. Next, Milord, para 23, next page.
yes.
But it is true that section 311 of the code as well as section 138 of the Evidence Act provides for recall of the witness and deals with power of the court to summon material witness or examine person present at any stage of any inquiry, trial, or other proceeding under the code, even to examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined if his evidence appeared to it essential to the just decision of the case. Next, Milord, the Honorable Apex Court has set out the following principles to be borne in mind by a court, which are reproduced hereunder for profitable consideration of the case in the following paragraphs. The first one, Lord, whether the court is right in thinking that the new evidence is needed by it, whether the evidence sought to be laid in section 311 is noted by the court for a just decision of the case. Next, the exercise of the widest discretionary power under section 311 CRPC should ensure that the judgment should not be rendered on inchoate, inconclusive, and speculative presentation of facts, as thereby the ends of justice would be defeated. Next, if the evidence of any witness appears to the court to be essential to the just decision of the case, it is the power of the court to summon and examine or recall and re-examine any such person. The exercise of power under section 311 CRPC should be resorted to only with the object of finding out the truth or obtaining proper proof of such facts which will lead to a just and correct decision of the case. Next, the exercise of the said power cannot be dubbed as filling in a lacuna in a prosecution case unless the facts and circumstances of the case make it apparent that the exercise of power by the court would result in causing serious prejudice to the accused, resulting in miscarriage of justice. Lord, this one is important and applicable in my case. Next, Lord, the wide discretionary power should be exercised judicially and not arbitrarily. The court must satisfy itself that it was in every respect essential to examine such a witness or to recall him for further examination in order to arrive at a just decision of the case. The object of section 311 CRPC simultaneously imposes a duty on the court to determine the truth and to render a just decision. The court arrives at a conclusion that additional evidence is necessary, not because it would be impossible to pronounce the judgment without it, but because there would be a failure of justice without such evidence being considered. Exigency of the situation, fair play, and good sense should be safeguarded while exercising the discretion. The court should bear in mind that no party in a trial can be foreclosed from correcting errors, and if proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistakes to be rectified. And my lord, how magnanimous has to be interpreted and understood, that my lord, Ram Meher, my lord, has considered. Next, the court should be conscious of the position that after all, the trial is basically for the prisoners, and court should afford an opportunity to him in the fairest manner possible. In the parity of reasoning, it would be safe to err in favor of the accused, getting an opportunity rather than protecting the prosecution against possible prejudice at the cost of the accused. The court should bear in mind that improper or capricious exercise of such discretionary power may lead to undesirable results. And next, my lord, next three, my lord, I am not reading, 14, 13, 12, 13, and 14. My lord, another is para 25. My lord, AG versus Shiv Kumar is another judgment of the Supreme Court, which was also relied upon. My lord, I'll read, my lord, some of them. The trial court, my lord, the first one in 25. The trial court and the High Court held that the accused had appointed counsel of his choice. He was facing trial in other cases also. The earlier counsel were given due opportunity and had duly conducted cross-examination. They were under no handicap. Next, no finding could be recorded that the counsel appointed by the accused were incompetent, particularly at back of such counsel. Next, expeditious trial in a heinous offense, as is alleged in the present case, is in the interest of justice. The trial court as well as the High Court rejected the reasons for recall of the witness. The court has to keep in mind not only the need for giving fair opportunity to the accused, but also the need for ensuring that the victim of the crime is not unduly harassed. Mere fact that the accused was in custody and that he will suffer by the delay could not be consideration for allowing recall of witness, particularly at the fag end of the trial. Mere change of counsel cannot be ground to recall the witness. There is no basis for holding that any prejudice will be caused to the accused unless the witnesses are recalled. The High Court has not rejected the reasons given by the trial court, nor given any justification for permitting recall of the witness, except for making general observations that recall was necessary for ensuring fair trial. This observation is contrary to the reasoning of the High Court in dealing with the grounds for recall, that is, denial of fair opportunity on account of incompetence of earlier counsel or on account of expeditious proceedings. And there is neither any patent error in the approach adopted by the trial court, rejecting the prayer for recall, nor any clear injustice if such prayer is not granted. So, my lord, next, my lord, one more paragraph I'll be relying, and I'll be finishing off the page 7, para 28. Next page.
Yes.
My lord, it says it emerges from the principle laid down by the Honorable Apex Court that for invocation of section 311 of the code and its application in a particular case can be ordered by the court only by bearing in mind the object and reasons of achieving a just decision of the case. But it shall not be with a view to permit the prosecution to fill up the lacuna in the prosecution evidence. And it should be with the object to discover relevant facts. So the provision under section 311 of the code should necessary the questions to be put to the witness on recall. So, my lord, I have relied on 3 judgments of the of different courts, my lord, and the propositions, my lord, which comes out from this judgment is, my lord, that 311 gives widest power to the learned trial court and can be invoked at any stage of the trial. That the statute is clear, and on a on plain interpretation of the statute, my lord, it can be inferred. But there are certain checks and balances, my lord, which comes from the judicial decisions of this country. So, my lord, those checks and balances has to be kept in mind by the learned trial court while exercising its power under section 311 of the CRPC.
Yeah.
So, my lord, in the present case, as the defense has alleged before this court, though his counterpart in the trial court has not said anything, so, my lord, as my learned friend is saying here before your lordship, on every occasion, my lord, every application filed by the prosecution was heard in presence of the defense. Lord, they made their submissions, they did not raise objections, that was allowed. Subsequently, my lord, time was given to them. The time gap between the examination of the witnesses, my lord, were sufficient enough for a prudent counsel, my lord, to get himself ready, particularly in a matter which is of serious nature, my lord. And in the present case, my lord, there is no latches on the part of the prosecution. Rather, the prosecution, my lord, as per the provisions of the POCSO Act, has tried that the matter, that the trial gets disposed of at its earliest. My lord, if the prosecution would have delayed the trial, my lord, he would have come before this honorable court and said, see, the trial is delayed, grant me bail. Now, my lord, when the prosecution is trying to get the trial disposed of at the earliest, my lord, he is saying it is a hurried trial. So, my lord, whichever way, my lord, the prosecution goes, the defense will try to catch him in one way or another. So, my lord, this is not a case, my lord, where 311 petition has to be allowed. My lord, the learned trial court, with proper observation and with just reasoning, has rejected the application, and that is correct. So, my lord, no interference is warranted in that order at this stage, my lord. So, that is my humble submission before your lordship, my lord. I rest my case.
Yes.
First of all, my lord, this is a case of the, my lord knows better. Has been sexually ravished and thereafter brutally murdered. The evidence, the material which has been collected and thereafter charge sheet has been submitted and trial has been. But I am my learned friend already elaborated, discussed, but I am not regarding that. My lord, I am submitting the list of dates, my lord. This is a one by one, my lord. That is very helpful for my lord, the passing the judgment. And my lord can appreciate, my lord, the PW1, PW7, PW12, PW13 and 14 and 16 PW. Already, my lord, and there is a opportunity and the time of the defense witness, they can, but they didn't. And my lord, for PW16, my lord, executive magistrate court. Executive magistrate কত ছিল রে? Executive magistrate 160 হ্যাঁ ওটা না PW তে কত ছিল? Executive magistrate ছিল executive magistrate PW কত ছিল? 16 কি? Executive magistrate কত ছিল PW? না না 311 এর চেয়ে ছিল তো 311 এর পিছে ভাই না এক্সিকিউটিভ ম্যাজিস্ট্রেট এটা কোথায় executive magistrate who conducted the 164 statement, judicial magistrate, but they also called for and for DW.
Judicial magistrate was not examined on behalf of the prosecution?
Yes, no. For that is the only, and for DW, question has been made, and for DW2, the appearance has been called for, And that has been solved, my lord.
They have given two witnesses.
My lord. And my lord, on third page, my lord, you can appreciate how many questions have been made for PW1 to PW22, my lord.
Hmm.
First section is for prosecution witness and second section is for defense witness. Defense question, my lord. My lord can see chronologically how many questions has been made. So there is no any doubt regarding the huge opportunity given by the prosecution or by the system, by the trial court. And Madam can appreciate this is a POXO case for trial, speedy trial. This is a mandate. There is no any lacuna in the part of the prosecution that's for de novo trial.
Yes.
My lord, you can appreciate, my lord, how brutally murder has been occurred. The face has been totally pushed and disfigured by the present petitioner. And all the CCTV footage and
Then I appear for the opposite party number 2 on the last occasion on the
My lord,
the petitioner, your lordship was pleased to fix the matter today. And there was also a network problem, so
You are for opposite party.
opposite party number 2.
My lord, I'm appearing for the petitioner. I'm led by Mr. Amalesh Rai in this matter. He was here yesterday, but he had to leave for principal bench urgently this morning, my lord. So I'm praying for next circuit.
My lord, on his prayer, my lord, the matter was fixed and I have come for hearing, my lord. My lord, he can join online.
My lord, he has an urgent matter fixed in principal bench. That's why he had to leave this morning, my lord. We're praying for next circuit.
Last day you could have submitted.
He was on his legs, my lord.
They have come up for quashing in a case of forgery, but investigation is going on and this ritual has been rejected, then this application has been filed. There is no cooperation from the end of the accused in the investigation.
Now he's in custody or?
No, their friends will be turned down by this honorable court.
My lord, in that case, kindly next week then take instructions from my senior lordship.
There are many matters next week. Next week we have 3 days.
Yes.
Friday, there will be so much cases.
My lordship, in that case, kindly next circuit.
Join online on the principal bench. At 2 p.m.
Lordship, he has an urgent matter fixed. That's why he had to rush this morning. Kindly, I'm praying.
Hold up the day.
Kindly, I can take it.
Online.
That is why I'm praying for him.
On their prayer, the matter was fixed.
Lordship, kindly next.
What to do with?
Lordship, I'm humbly praying for next circuit. Sure.
You see, you have to think over now. People are coming, the matter is not being heard. The person who was here, he has gone to Calcutta. Now he was in Calcutta, he has come to. He was online. Everybody was present. Mr. Roy was not present. On behalf of Mr. Roy, the date has been fixed after hearing you.
Lordship, Tuesday, I'll take instructions, Lordship.
What instructions?
We will Tuesday, I'll inform him.
Not today.
And the difficulties, last time also when I appeared online, there was a problem with the network. So I thought it prudent that it's better to address your lordship physically.
Because once we step into next week, everybody knows that there are many matters that has been fixed. And the matter could not be taken. But it's not possible.
Instruction from the senior lord, if it can be taken up today at 2 p.m.
Because 2 p.m. I will be taking up civil matters. That is the difficulty. Is there any interim order?
No.
No.
That's all.
Next week I'm placing, but I don't think we can reach.
May I make a humble prayer with the lord? Can it be fixed on Tuesday at 2 p.m. so that it can be taken?
2 p.m. the matters, civil matters are there. 18th রাখুন তো দেখি কি হয়। Mr. Counsel Learned Advocate for the petitioner seeks accommodation. Mr. Ranodev Sengupta Learned Advocate for opposite party number 2. Huh? কি করবো? উকিলবাবু না আসে তাহলে 19th 20 তারিখ ক্লাস করে দেবো নাকি 20th June?
20th in that case, my lord, I should pray for leave to join online.
On Tuesday, you will come physically.
Perhaps because another cancellation matter may be taken up on Tuesday before the honorable division bench. I'll try to come.
ঠিক আছে তো কি ওটাকে 18th দিই নাকি শুধু 18 না 20th
Tuesday dating.
কাকু টুইস্টে তো দেখো
Can time be fixed so that it's taken up?
time I cannot fix it.
On indulgence.
Time I cannot fix. On 18th I am keeping. If there are less matters or the matters are if the matters get adjourned, so if I reach I can take it up.
I can pray for
Great
that.
for
liberty.
Carry on 18th. 18th रहेगा 6 accommodation 18th April.
Grateful Lordship.
CD is required. CD is available. Okay.
Grateful Lordship.
They brief there.
11.
On last occasion, equal also can take the order to 10th June. I have filed
Next,
the
Deputy.
opposition.
Where is the reply?
There is no.
Reply is not required.
But
Not
that-
required.
We had an impression that they will reply because they have submitted equal lordship.
No, I say.
1 minute. If your lordship kindly take the order, your lordship, the order is very clear.
Well,
Kindly wait. I will invite your lordship's kind attention about the order passed by your lordship. And on the basis of that order, we had an impression that they will take an exception and file a written reply. Now they have said we will not file any reply.
My learned friend was present on that day. I said on that very day, Milord, he handed over me the copy of the opposition. I said,
Obviously.
"Sir, please allow me to speak." On that day, Milord, when I received the copy, I said, Milord, I do not know what they have written. If required, I will give my reply. After going through it, Milord, I think there is no necessity of filing a reply, Milord. It can be argued.
The Malad, that is there.
Sir, one cannot be forced to file a petition.
Yes.
No, my lord, that is fact. But we had an
He has
impression.
submitted
May
that
fix
he
the
will be
Tuesday.
Now he comes up and says that, see, I have gone through it,
Okay,
it is
now-
not required.
My lord, one indulgence I am seeking. I had an impression that they will take some exception. And for that reason, I've got.
My Lord, he has a
let-
hidden prayer in his submission.
No. May fix the Tuesday.
Yes,
No.
that is the
No
original
prayer
prayer,
was
my
there.
Lord. That is the original prayer.
If that order was not passed, if they did not say anything in that fashion, I will prepare myself. Why will my prayer be hidden? I have to come before your lordship with my
Milord,
hand.
in that case, Milord, this is a case where Milord took one partnership firm represented by my learned friend and one private limited company.
No.
Sir, please.
No, one indulgence.
Allow to speak, Milord.
Whether the matter will be taken up, then the matter will be taken up
No.
on Tuesday.
Allow me
Because
to say something, sir. You are not the only person before the court.
No. I am not in person. But if that you have said, you will file exception. But today you did not file. It's okay. We're ready to hear, but give me 1 day accommodation.
I have understood that you anticipated him to file a reply. Now the reply is not here.
That is my.
Now you are not ready with the case because you are in anticipation the reply would have come up.
That is my contention.
Yeah, I have understood. Mr. Bhomik, let Mr. Chaudhary submit. Okay. Yes.
Now, Milord, this is a case where, Milord, one company and one partnership firm, they are into a business transaction. Milord, my client is a company based in Vijayawada, based in Vijayawada in the state of Andhra Pradesh. Milord, they are in the business of manufacturing foods for the fishes, fish foods, Milord. And Milord, his client is in the business of supplying the raw materials. So, Milord, from the year 2022, Milord, the business was going on between the parties. Milord, around 70-80 lakhs of business was already going on. Suddenly, Milord, in the year 2023, a consignment received by my client of around 12-13 lakh rupees, Milord, they found that the quality of the material supplied by his client is not up to the mark, is of a substandard quality.
Milord, that was sent to the laboratory. Milord, they have their own laboratory. It is a big company, Milord. They have their own laboratories. It was sent to the laboratory. The laboratory gives a report that these products are of substandard quality and cannot be used for producing the finished product, the goods. So, Milord, my client gives a mail to them. Lying in my godown, you take it back. Milord, they did not respond to that. They say, we have supplied you the goods, you give us the money. You give us the money. Milord, I stayed calm. I said, sir, I do not need your products because it is of substandard quality. You take it back. I have no difficulty with that. They did not take back the goods. They file a private complaint under 200 CRPC before the jurisdictional magistrate. This is the case. Now, Milord will find in my application, Milord, the case was filed under section 409, my lord, 409, 406, 419, 420, 418, 384, 386, 477, Milord, all the sections of the IPC, Milord, whatever they could gather, Milord, they put it in the complaint, they filed it before the learned magistrate. Lordship, from the genesis of the case, Lordship can aver that this is a case of commercial transaction between two business concerns. And that business concern, businesses between them were going on since last 1.5 years. That is admitted by them in their opposition. That business was going on, except this 12 lakh, 13 lakh rupees, all the payments were made, were cleared earlier. But for this payment, they are not making the, for this consignment, they are not making the payment. And as such, they had a deceitful intention to deceive us. So the case lies under section 420, 409, 406, 384, whatever, extortion, everything they have put in the private complaint. So, Milord, this is an abuse of the process of law. Milord, the learned magistrate should not have taken cognizance of the complaint itself. I do not know, Milord, how he has taken cognizance. So, Milord, this is the crux of the matter.
Where is the agreement between the parties?
No agreement, Milord. I was the purchaser, he was the seller.
Okay.
And Milord, unless, Milord, being a reputation, Milord, if I do not maintain my, because I export goods to other countries too, Milord. In the state of Andhra Pradesh, Lordship knows, Milord, the fishing business, Milord, is of paramount nature. So, Milord, I supply foods to the fishes. I export my products outside India. So, Milord, that is my paramount duty to maintain my standards of my finished products. So, Milord, if they do not provide me the raw materials of the quality I require, Milord, there is no the point in taking the business further. I asked him to take it back, he will not take it back. Milord, this is more of a like a, Milord, in Bengali we call Jorjar Mulluktar, Milord, like it is a situation like that.
No.
Yes.
Milord, actually, my position I have already cleared. When if you want, in reply, I can, at the 10:30 on Tuesday, I can reply. At the top of the list, I can appreciate your lordship properly. Because there is some discrepancies in his submissions, because they took articles from me long back. When I created or asked them to clear their debts, they showed some fictitious mail. Whether those were sent to us, no sent items were attached with their petition. If, for the sake of argument, my lord, if I send a mail, there a copy will be saved in the sent item folder. That can be said the mail has been sent. From my own folder, I can print out a mail and I can produce the same. But if there is any folder, if that is printed out from the sent items folder, then that will be sent, that will be said that was sent. Now, if we take that claim for a moment, Lord, that so far their impure mails are concerned, they have downloaded from their own inboxes, not from sent item folders. For that reason, I am seeking at the Tuesday at the top of the list. I will appreciate your lordship properly.
Lord, without looking into the papers, my learned friend
with looking into the paper, kindly check your papers, then can say.
Lord, without looking into the papers, my learned friend is saying that there is some discrepancy with regard to the email.
No, that is my only point.
Lord, I will not look into the papers. I will not go into the email. He is saying that I have not sent the email and he has not received the email. Where from this email has come, they do not know. My lord, for the time being and for the sake of argument, let us assume there is no email. I have not mailed them. Does that make it a criminal complaint?
Obviously. I will
Does
show.
that, does that make it a criminal complaint? My lord, when business transactions going on between two parties, and for the sake of argument, my lord, I have not paid payment for a particular consignment. My lord, what is their remedy? What is their remedy? My lord, recovery of money they can file. 12 lakh rupees, more than 3 lakh, that means Commercial Courts Act is also applicable. They could have approached the commercial court. But this is a dispute of commercial nature, civil dispute. My lord, criminal jurisdiction, my lord, what will happen? For example, my lord, if I am convicted, what they will get? The money, they will get back the money. No. Then what is the necessity of invoking the criminal jurisdiction, my lord? Just to insert pressure that no, I have given you substandard products, you have to keep it, you have to pay me the money. Otherwise, I will file a criminal complaint.
Yes.
No, my lord, one indulgence in reply. I have been entrusted.
Then you are ready with the case.
No, my lord, maybe I will analyze some documents to show. For that reason, I am saying at the top of the list on Tuesday, I will appreciate your lordship properly.
Mr. Arjun Chaudhary, learned advocate for the petitioner, submits that his client shall not file any affidavit in reply to the affidavit in opposition filed on behalf of opposite party number 1. Mr. Joydeep Kanto Bhaumik, learned advocate for opposite party number 1, seeks accommodation. Or 18th and 19th regular. Oh. Let the matter appear on 18th or 19th.
This is 19th actually.
19th. Okay. Draft password.
I'm for the petition.
What is the order impugned?
In the order impugned, my lord, the application under Order 26, Rule 9, CPC has been rejected.
You are plaintiff.
I am plaintiff.
And what is the suit?
The suit is for declaration of title, recovery of possession, and other reliefs, permanent injunction and other reliefs.
Yes.
My lord, the plaintiff has filed this suit for declaration of title, recovery of possession, and other reliefs. At the first instance, when the suit has been filed, thereafter an injunction order was passed, and the defendants violated the injunction order. Accordingly, a petitioner filed an application under Order 39 Rule 2 SCPC, in which the miscase has been registered and an order has been passed by the learned court in the said miscase. Kindly come to the page number 45. '47. Learned court find where there is no demarcation of the suit land and possession of the lands of the petitioner as well as the opposite parties are adjoining, there is every chance of mixing of 47 page number. Where there is no demarcation of the suit land and the possession of the lands of the petitioner as well as the opposite parties are adjoining, there is every chance of mixing up the properties by undemarcated boundary. I do not find any prayer for local inspection commissioner or investigate commissioner to make out the prima facie case in favor of the petitioner that the tree bushes are actually existing and were cut down and damaged and taken away by the opposite party. There is no specific boundary of the suit property. The local investigation is very vital step to distinctly identify the suit property. This was the first, in previous occasion, the finding of the court. And it is also the case of the defendant. In their WS, they specifically questions about the identification. In page number 35, last part, para 6. The suit land is not identifiable. Description of the suit land is vague, incorrect, and motivatically false.
So it took 10 years for the plaintiff to file an application for getting it
No.
investigated?
Yes, after the evidence of the plaintiff is done, then we file the Order 26 Rule 10. Before evidence of the defendant. Defendant did not produce given any evidence. Prior to the defendant's evidence, this application has been filed.
Okay.
But learned court, although he on the first occasion he had found that the identity is required to be is in dispute, but in the impugned order it is stated that now it is settled principle of law in the impugned order. Now it is settled principle of law that the local investigation is best way to find out the possession where the dispute regarding the identity of the property. And thereafter finds that there exists no dispute about the property, its identity and measurement. More so, the plaintiff asserted the right of possession so and so. And had rejected the application of the petitioner. It is their case that the suit land is also not demarcated. They in their written statement page number 37, again in para 10, repeatedly stated that the suit land is not demarcated. In para 10 last part, those are based only on two registered deeds executed and registered by Lotus Private Limited, covering such land which has never been demarcated or partitioned. So this is the paragraph 10 last part.
This is a joint property.
No, we have purchased. They had their case is that they are the squatters. They had no right title interest. They paid for an application for lease and this is to the government, and all these things are there. They possess, they are in possession, and we also, it is recovery of possession. Our case is that. That is not, possession is not in
purchased the
dispute.
land.
Huh?
You are the purchaser.
I am the purchaser.
You have sought for recovery of possession.
Recovery of possession, declaration title, recovery of possession. And so the question of possession is not disputed. But learned court on that in the impugned order found that to prove the possession, we have prayed for recovery of possession. The power of appointment of commissioner for local investigation, the last part of the order, the power of appointment of commissioner for local investigation cannot be exercised by the court to enable any party in evidence through commissioner to prove the factum of possession and enjoyment. It is our case that they are in possession. We have filed the suit for, for recovery of possession. So the determination of possession does not arise.
Okay. Yes, that's all.
No. In this respect, some citation I want to refer on. Firstly, the judgment of the Honorable Supreme Court reported in 2000 Volume 3 SCC 728. 728. Dispute, Survey Commission dispute with regard to the land as to whether it falls in particular so and so. All the courts below decreed the suit, held that there was a serious dispute as regard to the area boundaries of the land in question, especially with regard to the identity. The courts below, before decreeing the suit, should have got the identity established by Surveying Commissioner.
Yes.
Another judgment of this coordinate-based judgment of this court. Now, in this case, my lord, there was also a dispute into the extent of possession, that is, of possession by the parties. In the para 5, in the last part, therefore, I find that there is a dispute as to the extent of possession by the respective parties in respect of the properties described in Section 1. Such dispute between the parties is nothing but a boundary dispute. such boundary dispute could be solved by appointment of survey commissioner by holding the local investigation and thereby deciding the extent of possession of the lands by the respective parties. Here is also the extent of land encroached is to be shown. Now, another judgment reported in 2008 SCC, volume 8 SCC, 671. In para 4, admittedly, in this case, the application was filed for under Order 26 Rule 9 CPC, which was rejected by the trial court. But in view of the fact it is a case of demarcation of the land, it was appropriate for the court to direct investigation by appointing the local commissioner under Order 26 Rule 9 CPC.
Where is the plaint?
Plaint. Page number 25.
No, this is not a case for recovery of possession.
Yes, ma'am. Para 14.
14.
14. Accordingly, pair is para 16 or B1.
The defendants are the workers of the tea estate.
No.
Then how they?
Defendants are claiming that kindly come to the page para 8 of the page number 30.
No, in the plaint, what is the status of the defendant? In the plaint, what is the status of the defendant?
They in the claim. They are the trespassers.
Trespassers.
14C. Para 14C.
That's all.
The learned trial court in the impugned order used that the same is the collection of evidence on that ground. Yes, in this respect, I like to refer one judgment of the Calcutta. Here, details have been discussed. But what are the
Which paragraph?
From 10 onwards, it is about order 26 to 9 and 10 it has been discussed. From para 5, it is the provisions firstly mentioned. And finally came to this conclusion on para 10. The above referred view can also be justified from another perspective. Under order 26 rule 10, as noticed above, the report of the commissioner and the evidence taken by the team is a piece of evidence. The word evidence is not defined under the code or under the Indian Evidence Act. However, the Indian Evidence Act, among the others, deals with the oral and documentary evidence. The report of the court commissioner should be documentary evidence under the Indian Evidence Act. The party to the suit is entitled to produce the documentary evidence in support of his case, subject to the court to the relevancy of the document. In the view of the matter also, the contention that the appointment of the commissioner for local inspection or scientific investigation amounts to collection of evidence, and for this reason the application is maintainable, is not valid or not valid. The application is not is maintainable, is not valid, not contextual. On other hand, the party to the suit in the appropriate proceedings is enabled under the law to this case to the report of the commission. Thus, in a given case that calls for the appointment of commissioner, if the application is rejected, the same amount to the denial of the permission to lead evidence. The appointment of commissioner for local inspection or scientific forensic investigator is indeed to secure the evidence, and the same is not only permissible but also desirable in certain. The report given in the intrinsic complexities of the matter in case may go a long way in arriving at judge decision or assisting the court to appreciate the other evidence in the report or the fact of the situation in that matter. If the report of the commissioner is nothing to do with the subject matter in this court, then there cannot be an order of appointing the commissioner. Order of appointing the commissioner can be made when the commissioner report becomes relevant piece of evidence. That being the position, the contention that the appointment of commissioner amounts to collection of evidence at the moment. So on collection of evidence ground, on the ground of collection of evidence, order 26 rule 9 cannot be given. It may have relevance in order 39 rule 7, local inspection. There is difference between local inspection and local investigation. Local inspection under order 39 rule 7 and local investigation under order 26 rule 10. Order 39 rule 7 is the injunction petition, prima facie case. That is the procedure. Order 39 is procedure for injunction. And on for that injunction, that what is required and all this. For that, in that order 39 rule 7, the collection of evidence cannot be done. Is that right at a preliminary stage? But order 26 rule 10 itself is the evidence. So it amounts to collection of evidence. That's one. Now another point is also here discussed. The next question is that at what stage the proceeding the application can be. Here, Planet below has stated that so much delay. So delay is not the question. Here I also discussed that at what stage of the proceeding the application is. As could be easily noticed in the provision is not state centric. The provision is not state centric.
Paragraph.
Paragraph 30. The next question is I will not given me appear. The next question is at what stage of the proceeding the application as could be easily noticed from the provision is not state centric. Thus the provision can be invoked either before or commencement of trial or after. If the application is filed before commencement of trial, court having regard to the pleadings and reports may allow such application before commencement of trial. For example, in a given as well. So it is not a state centric. It can be before or after or at the time.
That's all.
Now, now when learned trial court, one view that I have referred in just.
Yes.
Just as I stated just before, that Lanet trial court once viewed that the local investigation is a necessary step to be done. And then again, when the application was filed, that has been rejected, that the collection of evidence, identity is not. Once he says that identity is to be determined, since unless local investigation is done. And the next time he is saying that no, it is identity is not. So both the judgment of the orders, it kept side by side.
That is passed in miscase.
In the miscase, arising out of this case, in this case. Violation.
The rejection has all been done since identity is not challenged.
Rejection is identity, there is no.
Challenge to the identity because it says that order 2609 is required for ascertaining the identity of the person. Written statement, identity challenge. And the court also said at one point of time that inspection is necessary for.
Because identity.
You go on. After recess, I will take it. Recess. 2 PM এ যেটা আছে 2 PM এর পরে ওটা তো হয়েই আছে।
Kindly do not take me wrong.
Oh, Mr. Jana, the matter was passed over. Mr. Chaudhary went out. The next day.
My lord, then Tuesday.
On 18th, it will be listed on 18th.
On 18th, my lord, it will retain its position.
That is the difficulty because 18th there are other matters.
My lord can fix it on 19th also subject to lordship's kind convenience.
Achha.
I have no issue. My lord, if it can be fixed at 10:30 or 11, anything, subject to your lordship's kind convenience.
19th তাহলে দিয়ে দিন 19th.
My lord, can it be at 10:30?
Item number 12, no?
Item number 12.
ठीक है. Mr. Chaudhary?
Yes.
On 19th, it will come.
My lord, can it be at 10:30?
So, there are other matters also.
Other matters. No, my lord, since my lord, your lordship is taking up both civil and criminal matters, there is a lot of pressure. That is why I am saying, my lord, now Mr. Chaudhary has also seen the judgment which I am relying. Only, my lord, there will be a discussion and it can be over by 15 to 20 minutes.
Okay, we'll see how it goes on 19th. Let it be listed on 19th. Huh?
I'm grateful.
কার চলে যাচ্ছে? না আছে। চলি। No mentioning right now. Or the supplementary list. Release on which day you come? It has been released, you will list it. Not now. Yes. Supplementary list.
My lord, they have brought the entire judgment balance yesterday. Kulbhushan Kumar's judgment.
Kulbhushan?
Yes, ma'am. It is not, the soft copy is not available, my lords. So my lords, I took it out from the, my lords, from the book, the law reporter. Lords, kindly see.
But then the decision which has been referred by you of Allahabad High Court
My lords.
records. See, para 14 you have referred, but that is not the proposition laid down by the Honorable Supreme Court. See, you have the copy of Kulbhushan Kumar?
Yes, ma'am.
Come to para 19. Para 19.
19.
See, the sentence in that paragraph begins with
This provident fund is also included, my lords. But that
Yes.
won't make any difference, my lords, because
it makes a hell of difference. Hell of difference. Because yesterday when I was hearing, she said that net income has to be considered. Now 31,000 less 150. So GPF contribution is being made by the party. That is 6,000. As per Kulbhushan, that amount is to be deducted.
my lords.
But the Allahabad High Court says that no, this should not be deducted as per Kulbhushan.
Yes, ma'am. My lords,
Huh?
there are other
Para 14 is
judgments
a,
also, my lords.
para 14 is a wrong recording and wrong finding basing on a judgment of Supreme Court. It says, see, para 14, no deduction is permissible for payment of house rent, electricity charge, contribution of provident fund. This contribution of provident fund, Supreme Court says that it has to be deducted. Allahabad High Court recording the judgment of Honorable Supreme Court says that it should not be deducted.
My lords, not only Allahabad High Court, my lords. My lords, one more is there, my lords.
Don't place those judgments. Now we have Kulbhushan, income tax and provident fund is to be
Is
deducted.
to be done. My lords.
Yesterday, I was asking for that judgment. Now, since there was a reflection in the judgment of the Honorable Allahabad High Court, I proceeded to dictate. But thereafter, in the evening, I find out that the propositions has been wrongly recorded in the Allahabad High Court judgment.
And also in the Karnataka High Court, my lords, the same observation is made.
So, we follow Kulbhushan. আসুন একটা বলা আছে সাবমিশন বলা আছে
His income from other
From
sources
the-
also needs to be taken into consideration, my lord.
from the impugned order under challenge, it is found that the learned trial court has proceeded holding the income of the petitioner husband to be rupees 30,000. Considering the gross salary of rupees 28215 for the month of March 2022. It has been strenuously argued on behalf of the petitioner husband that the learned trial court ought to have considered the net income. On the contrary, learned advocate for opposite party wife, relying on a decision of Allahabad High Court, reported in 2024 AHC 45615, submitted that the net income should be considered deducting only the tax component from the gross salary. In order to ওপরের পোর্শনটা বলতে হবে গো। ঠিক আছে। In order to appreciate the rival contentions raised by the learned advocates for the respective parties, it would be relevant to refer to the decision of Honorable Supreme Court passed in Dr. Kulbhushan Kumar versus Srimati Rajkumari, reported in 1970, Volume 3 SCC 129. Para 19 টা কোট করব। Para 19, Upon going through the aforesaid proposition, it is found that the Honorable Supreme Court has laid down that the income tax as well as contribution to the Provident Fund is deductible. The affidavit Annexure P1 to the affidavit filed on behalf of the petitioner husband, within bracket, pay slip for the month of, it is for which month? April 2024, shows the gross salary to be 31610 and GPF of rupees 6,000 and professional tax of rupees 150. Stop. Following the aforesaid observation of Honorable Supreme Court, the net income of the petitioner husband comes to $25,460. It is also found from the certificate annexed to the affidavit filed on behalf of the opposite party number 1 that she is getting an honorarium of 11,255 working as a working as Sahayika at Dhukuria Shishu Shikha Kendro under Pathorghata Gram Panchayat of Matigoda Development Block. Judgment the valuable. In Kullan De Chaudhary Supra, the Honorable Supreme Court observed that the amount of permanent alimony awarded to the wife must be befitting the status of the parties and the capacity of the spouse to pay maintenance. Maintenance is always dependent on the factual situation of the case. Dependent on the factual situation of the case. And the court would be justified in molding the claim of the maintenance based on various factors. Bearing in mind the aforesaid principle, hence also keeping in mind that the opposite party is receiving an honorarium of 11,255. This court is of the view that it would be reasonable. Achha, sorry. No. The object behind enactment of section 24 is for needy persons who, in spite of sincere efforts and sufficient efforts, are unable to support and maintain themselves and are required to fight out the litigation, jeopardizing their hard-earned income by toiling working hours. Therefore, since the opposite party wife is getting an honorarium of rupees 11,255, it would be reasonable and rational to modify the alimony pendentillite of rupees 9,000 to rupees হচ্ছে কত বললাম 25,000 to rupees 7,500. Accordingly, the revisional application stands disposed of or is allowed in part. Allowed in part, the impugned order of the learned trial court dated 7th October 2023 is modified to the extent that the opposite party wife shall be entitled to receive alimony pendentillite to the extent of rupees 7,500 per month. Subject to the conditions as imposed by the learned trial court. All connected applications, if any, stands disposed of. আচ্ছা ওপরে একটা দিয়ে দিন. This matter is appearing under the heading to be mentioned. On the last date, that is গতকালের ডেটটা দিন. Yesterday. 13th.
Just 13th
June 2024, the matter was heard. However, due to certain clarifications, the matter has been posted under the heading to be mentioned. Affidavits filed on behalf of the respective parties in terms of order of this court dated 2nd May 2024 is taken on record. Thank you. Thank you.
I'm grateful.
Yes. কোন আগের অর্ডার ঠিক আগে ভাবে কি করে আমার কাছে পড়ে আছে সার্ভার কি করে দেবো না না হয় কালকে মাঝে কথা তো ওইটা চোখে পড়লো তাই করতে হবে থ্যাংক ইউ স্যার Now, next CO টা ওনার. Where is your other side? ওটাতেই আছে স্যার। এই শিবানীবাবু, ওখানে যে ফ্যাক্টটা যেটা আছে, ব্রিফ ফ্যাক্ট, সাবমিশনস, এভরিথিং হলো, এরপরে এটা ইনকর্পোরেট করো, ঠিক আছে? ইয়েস।
Before he starts, I'm saying, concluding part, some part.
Again,
Huh?
you have concluded.
Some thing is to be stated. Okay, okay, I'll give the reply.
My lord, so far order 26 to 9 in concern, my lord is there with us, which was the appointment of commissioner only to go for adjudicating the matter for this week. That has been. Now, my lord, the petition for order 26 rule 9 has been filed by the petitioner that has not been found in the petition, in this petition. But what is their prayer in respect of order 26 rule 9? What is the commissioner will go to ascertain that has not been found? That has been, I am not found here there is any petition in the total petition. So it is not, cannot ascertain the what is their prayer in the in respect of the conclusion that they are claiming such part of property is needs to be investigated. This part of not that is been that cannot be ascertained, Lordship. So now
It is there in page 64, annexure E.
64.
No, it is order 20, where is it? 26 rule 9, page 64.
52. 64. This is the order, Lordship. Order.
What order? This is the petition.
64. 64, that is I am didn't get that is because of 63 thereafter I got the order from it.
Annexure E is there.
But they have supplied me that are incomplete. I didn't get the petition who was filed there. They didn't when they send me the copy, the petition has not been.
Your copy of the petition.
I'm getting the. I'm getting the copy. Lordship, as per the plaintiff's petitioner's contention in the petition, I find the plaintiff therefore submit that it is very much urgent to appoint a commissioner among service from BLR Jalpaiguri. So, and to ascertain this, what is the present feature of the suit land? First, what is the nature and character of the suit land? Because there is, who is the position of the suit land? Secondly, C is therefore, they stated who is the possessing the suit. They try to ascertain from the commissioner order 23 rule 9, try to ascertain who is possession in the suit. That is in there. Here, figure of statement and local figure. So, and the position, who is position, that cannot be ascertained by the commissioner because of the commissioner cannot go to who is the actual position. Whatever will Lordship. Now, their case actually. Page number 25 is their claim. Lordship, kindly come into the page number 25. Lordship. Page para 3, they stated that the plaintiff with the land in view of acquire the purchase the said tea plantation, cultivated, grown and developed vendor Lotus Project Private Limited covering area 17.52 acres with the model such and such. And therefore they stated that they are in the owner of the land in 74.52 acres land. Because of this suit for declaration. As well, this case suit is for the declaration in nature. And paragraph number 5. Kindly come to the paragraph number 5. The plaintiff, while in possession and management the state small tree project, got land measuring 9.47 acres covered by the plantation muted in his name, height mutation case number such and such, and existing position. Therefore, thereafter, passive, the plaintiff further states that some quantum of land where plantation of the tea cultivation is grown by the erstwhile vendor Lotus Private Limited having been found to be vested. And the plaintiff has also applied for long-term lease in respect of those land of the tea project and exclusively physical possession and the cultivation of the tea plantation free any question. Therefore, the part of the land they have been purchased as per their claim, some of the vested land. And declaration came, the declaration come forward from the plaintiff or petitioner, they were being owner. This is admission that there is a vested land and there is a plantation.
He has purchased the entire land, including the vested land.
Therefore, how can they purchase? Because of there is vested land. There is a vested land, there were the admitted. How much they are occupied, retained land, and how much vested, that has not been ascertained by them.
And order 26,
Lordship?
order 26 rule 9 will ascertain that?
No, Lordship, because of their Lordship, kindly come to that. The schedule, they have stated in the page number 30. Again, page number 30, this is the schedule, and 31, Roman 2, that is stated, this land parcel fell in possession, and they stated, and the last line, totaling measuring 7.84 acres, which the plaintiff has duly applied for long-term settlement before the authority. So they have no right over the property, but they applied for long-term or put to the appropriate authority. Now, which portion they have stated in a page number 32. So far, the opposite party respondent, the defendant is concerned, Lordship. Their version is, there is kindly looked into, that is between page 36, para 8. Get it, Lordship? Para 8, with reference to statement in paragraph such and such, it is stated that the answering defendants have gathered that the Lotus Project Private Limited was the owner of 9.9 acres of land situated in Moja, that is been stated in the which plot they are in. That the defendant who have been engaged in, this defendant is the opposite party, engaged in tea plantation in the above Moja for long time, having also come to know that the said Lotus Project Private Limited has unlawfully possessing the following lands, which have been categorized as vested land, that is been 5.71. There. Now, Lordship, there is a statement made in next that BLR Moinaguri and the learned DLR Jalpaiguri are believed not to have been considered the pair of the state Lotus Private Limited for granting lease patta in respect of the above land as yet. The alleged sale deed such and such is from their stated. Whatever they purchase the deed, they have been denied because of the erstwhile owner has no ownership over the land which have been transferred. Now, para number 12 of the page number 38. This is the version of the opposite party. On second para, I kindly draw attention to the second para number 12. There is a truth or should be disclosed or proper determination of the suit that the plaintiff has got physical possession of 9.447 acres by virtue of purchase by aforesaid two sales. He has started carrying the tea plantation of the purchase land under the name of Joydev Tea Garden. The defendants, on the other hand, have been jointly cultivated the tea plantation. This defendant is the opposite party here in 6.25 acres, which are classified as vested land for more than 15 years. They have been made of the officer of BLR and LRO Moinaguri for granting lease in their favor. That as per the advice of some officer of the officer BLR Moinaguri, they have been proceeded with the work of formation of self-help group, that is the SSG within bracket. They have been not small formation, they are small formation SSG by the defendant and others. The plaintiff who is trying to grab the land of the defendants become again an active prey for the BLRO Moinaguri for granting long-term lease in respect of the same land cultivated by the defendants. This is the defendants. This is the land which has been possessed by the defendants. They have been paid for a long-term settlement and they claim for that land. And now recovery position on that registry. How can that has been stated in the last paragraph? The description of the land under the long and peaceful occupation of the SSG, that is the opposite party, are as follows. 2.5 days, that is the statement they made, and 3.6, total in 6.25. This is their. So whatever the entire 75 acres land, out of that they are vested land and they are being occupied by the defendants. Or that is the opposite party. Now, Lordship, I come to the
What is the land occupied by the defendants?
document number 6.6 that has been vested land, that has been given by the government. By way of giving patta.
No patta is given.
Or that will be to prove it because of they stated here that
Who stated here? You have stated.
They landed my lord that come into the page number 57.
What about the rest land? Rest of the land?
9.17. 9.17 their position. They have been admitted because of they have been stated these positions come to the light of the in the year 2015 after filing of the WS, that is WS filing in the year 2013. Kindly give Lordship the WS filed in the 12 March 2013 and they have been alleged to be dispossessed in the year 2015. That can be found can you give me more? I will to this point. Lordship, kindly come to the only page number now. Page number 57. This is the cross examination of the owner of the property, that is PW1, that is the plaintiff petitioner. 57. I did not apply for patta of my vested land. 57, page number 57. Vested land in the appropriate authority. Voluntarily,
There is no 57 in this file.
57. They have been given 57. There has been deposition of the plaintiff number 1.
7.
There is not. Origination.
57, 58, 59.
दिए ना तो आज की ना पूंजी कार को देखो पेज तो नहीं देखी 54 onward there is
Well, pagination is wrongly.
What is it? 57. This is the version of the petitioner, para number 7. Fact that I have purchased property which involves with land vested and patta land. He stated, I cannot state specifically as to quantum of land which is vested under Moja such and such along with the purchase land. This is his version. He cannot differentiate his land. Now, para number 9, I did not apply for patta of the vested land for the appropriate authority voluntary acts that I have been applied for the long-term lease to vested land. Now he stated that he applied for a long-term lease, which land is being possessed by the opposite party. Now, page number 59. That is 59.
yes.
Fact that the certificate that second para, fact that the document to the DLR upon the application made by Lotus Projects Private Limited. Lotus Private Limited is the actual owner of the petition. Fact that certificate was issued in respect of 23.70 acres of the property in which some was vested land and some was retained land. I cannot specify the state of specific quantum of land which was vested or retained. He is not assured whatever the land he is retained, whatever vested. Now, vital portion of this details of the declaration is page number 63. Get it, Lordship? 63. Para 34. Fact that I have no document for my right title interest over the suit land except the LOI. LOI that is been given by the actual owner. That is been stated in the page number.
What is the full form of LOI?
LOI that is been long term. The LOI 59.
page number 15, they stated the LOI for their long-term license, I think, as per their version. So he got no right title interest over the land, but whatever he did get that are from the actual owner who got the land from the competent authority for the plantation. Therefore, the declaration of the suit is concerned, he has no right over the property. Now, 35 says the fact that I am not entitled to any relief till I am granted leave by government over the suit property.
35.
35 page 63 para 35.
I'm not entirely.
Last part. Therefore, Lordship, this plaintiff admittedly has got, he failed to identify his land. He admitted that he has got no right title interest over the property. And which property possessed by the opposite party, that is the defendants, tried to grab the land of this opposite party through by appointing a survey commissioner who can, as stated in his investigation, that who is in opposition. There has been evidence, sir. We're absolutely collecting evidence. This petitioner relied one citation in Karnataka High Court, Lordship.
Yes.
Therefore, defendants, that is the opposite party, has got some papers to occupy the land, vested land, and he has to go to prove the case when his term is coming to the plaintiff's side is over. He has been already adduced other evidence. Now, if the defendant has proved their case in respect of the suit party, then if court below is found that it is appropriate, then can we go for a commission. Now the stage, who is the occupier and how he is occupied the land, that is going to be determined. Because of this, plaintiff failed to prove his case because in respect of declaration title, because he got no title. The petitioner derived page number in a citation in Karnataka, that is in Sota Shankarappa petitioner. Lordship, can you come to page number 11, para 11 of that citation? Can para 11. What is your truth? The appointment of commissioner for local inspection, para 11, paragraph number 11. Or scientific or forensic investigation expert opinion is indeed to secure the evidence, and the same is not only permissible but also desirable in certain cases. The report given in intricate complexities of the matter in a case may go for a long way in arriving in a just and decision, or arriving the court to appreciate the other evidence on record, or fact, situation or proper perspective. If the report of the commissioner is nothing to do with the subject matter in dispute, Lordship, then there cannot be an order of appointing the commissioner. Appointing a commissioner can be made only if the commissioner's report becomes a relevant piece of evidence that bring the position, the contention that the appointment of court commissioner amounts to collection of evidence has no merit. This is 11. And then 12, paragraph 12 goes, under the provision of applicable for local inspection, what is impossible is the delegation of adjudicating power. To cite an example, if both parties claim to be in possession of the disputed property, the local inspection by a commissioner cannot be ordered to ascertain the possession. The question of possession is to be decided by the court. So possession is being decided by the court. It is stated. However, if one party alleges the encroachment by another and another party denies such allegation, the commissioner can be appointed to ascertain whether there is an encroachment or not. In such situation, the commissioner is appointed to find out the nature of the possession. The report based on local inspection will be handy to decide the case relating to the encroachment. In the case on hand, the petitioner to prove his assertion of the encroachment instead of leading to oral evidence of witness has applied for local inspection, and the same is not only permissible but also desirable. So therefore, when he stated that my land has been encroached, then can we come into the commissioner. Here is who is the possessor? Admittedly, I am in the possession because of I am planted here in the 15 years over the property.
Subsequently, there is an amendment in the plaint.
Lordship.
Amendment relates to recovery of possession.
Recovery of possession?
Amendment relates to the pleadings that you have encroached into the land. Whether you have encroached, that is something else.
Lordship.
But there is a pleading made in the amendment that you have encroached in some portion of land, which has led to filing of Order 26 Rule 9.
Lordship, my respectful submission on that point, Lordship, this is on the other hand, opposite party has been stated, I am in possession over the property and is the rightful owner. I am in the rightful owner. And he stated, by the way, that I am got from the Moinaguri BNL, they have been permitted to go for a plantation. And he has to prove that aspect. And prior to that aspect, how can it be proved that I am in wrong position? My position can be ascertained by way of permission that is being titled. Moreover, titled because of whoever the other was title holder, he given me permission to do that. Until unless that been proved, how can I prove that I am in wrong occupation? And if the occupation has come into that I am in position, that will be sacrosanct because of the I am in position. But my position should be first established is a legal position. That will be established first by way of my evidence. And Lordship,
But in the written statement, you also say that there is no demarcation.
I am in demarcation with respect of the vested land, my land property. His land is other land, because of he has to first prove his title. Over he is in planted the tea plantation going on. He has to first prove. Then come possession, because they have been stated in their presence. They are the title holder. Without title, this possession is illegal, Lordship. Their possession is now illegal. How can he call me that I am in illegal possession? If he has failed to prove his title, then his possession is wrong, bad in the eye of law. And that has been admitted from their version that I have no right over the property. So how can he prove his possession? Even his possession over that property, that has been wrong. because of he has got no title. Lordship, kindly come to the page number, their citation in the Karnataka in page, paragraph number 21, Lordship. This is their version in page number. Page 63, 34 and 35. Page 63, page 34, 35. Just admit it.
Yes.
Lordship, I kindly draw kind attention to the citation of Karnataka, page paragraph number 21. Yes, Lordship. 21. Having examined the provision referred in the above and given the facts, order 26 rule code of the order 26 of the code of civil procedure is often invoked in the trial court. This court of the view, for broadly speaking, in the following cases, the appointment of appoint commissioner to provide under order 26 of the code is desirable. There is a Roman 1, the dispute relating to easement of air, light, pathway, roads, water, etc. This is not our case. The dispute relating to the boundary or encroachment. Boundary encroachment, that is not yet. Because of no boundary, there he's got no boundary, this case. There is no boundary encroachment. The dispute related to forgery, that has been not their case. So this is their guidelines.
No, dispute relating to boundary, what do you mean?
Boundary inspector, he did not give any boundary, Lordship. He has not a boundary, specific boundary. Let us see their plaint, Lordship. The plaint is page number, schedule started from page 32, 32, 30, 302, 330, 32, 32. What is Lordship? They have no boundary. So how can encroachment has been proved? Because of he has got no boundary. So boundary dispute cannot be arised because of he did not demarcated his land by way of boundary. Then can say if his statement is there is even boundary, the boundary has been imposed. But there is no boundary at all, Lordship, in the plaint.
Yes.
Lordship, the Supreme Court 2008, Haryana Waqf Board, Lordship, kindly this. Kindly come to the para number 4, Lordship. Their case is appropriate for admittedly in this case the application was filed under 26 rule 9 of the civil procedure which was rejected by trial court, but in view of the fact that it was case for demarcation of the disputed land, it was appropriate for the court of direct illusion. It is their case, the dispute with respect to the demarcation. Their case, that case was not the here is the case. They let me my boundary be separated from there. That is not their case. that this is actually applicable that for the there is a specific demarcation, there is a boundary, and this boundary can be exact in my case, that can be separated from the others. In that way, the water toilet rule line is applicable. Proceed. They filed another Supreme Court cases that is been 2012 part 3 W. Vela Supreme Court. Oh, but in this case, Lordship, kindly come. I haven't found in this case, Lordship, para 66, 67, and 68.
Which one?
That is, they have not been given, but here is the honorable court specific findings on the paragraph 66, 67, 68. And I give you name. But the title is been confirmed, then position can come to the force.
What is the judgment? He has not.
Huh?
He has not referred to this.
No, but he give me this. I found that in this, but he does not rely. But I am relying on this. The paragraph number 60, 64, 65. Honorable Court here has specifically stated that when the title has been confirmed, then come into the position. Here his title is in dispute. That position has not been confirmed because of he is not given any boundary. Their position is in defect. He himself stated that I am not any documents to go substantiate my title over the property. No demarcation there. I am in position in another land. How can he establish that this land, his land is perfect and my land is unauthorized occupant? So, Lordship, the order 26 rule line is ambiguous, very much clear. If there has been dispute between the boundary or encroachment, order 26 rule can be invoked. But in this case, Lordship, the petitioner failed to prove his own land. How can it ascertain by the go to a commissioner can go for to and ascertain the position? Because his position is now in stake.
He is in position.
His position in another area. I am in another port, but his position over the land that has been not been confirmed because of he admitted that he has got no right title or interest over the land because he got the LOC. So far, land is concerned, he got LOC from the erstwhile owner, who erstwhile owner got the LOC, and by virtue of that LOC, erstwhile owner transferred the property. So erstwhile owner is not earlier owner, that is the Lotus Private Limited. He is not owner, actual owner.
What was the status of Lotus?
Lotus is the mere occupier, encroacher or occupier of the vested land, or he permitted to plant the property, planted anything more, and that has not been clear from the plaintiff side. But it is settled that he has got no right to over property because of he admitted on the fact. So far as the position is concerned, that been illegal. Once who is in legal, how can say that I am in legal? Therefore,
Correct.
order 26 rule is not existed because of my evidence is not be completed. Let I may become, I may produce my documents. And if the learned court below is not come into conclusion that who is the actual position, or what is the position, that then can order 26 rule 9 can come. And it is desirable. But until unless I am not in my produce my evidence before this learned court, that cannot be wise to go for a order 26 to go appoint commissioner and evidence is collected in favor of the plaintiff. So this stage is order 26 line is not applicable. The order 26 line is rightly rejected by the learned trial court, and that may be controversial.
Small reply. Learned friends try to mislead learned court in various ways. Firstly, the defendants in their written statement never asserted he stated that will produce all documents, never asserted a single document in the written statement by virtue of this I am holding the land or title or so and so. Now, what is the main thrust? It is the specific case of the plaintiff. উনি বললেন যে vested land আমরা অকুপাই করে আছি বা vested land. It is not the case of the plaintiff. It is not the case of the plaintiff that it is vested land is occupied by the defendants. There are two portions of the land. One is 9.47 acres. Another is 7.84 acres. Kindly come to the schedule on 30, page number 30.
What is the total land? 17.5?
Total 17 point. Total land is 17.34. Total land is 17.52.
No, where is your deed?
Yes, my lord.
Your deed?
Deeds.
Deed.
Deeds are not annexed here. So far the plaintiff is concerned, kindly come to the schedule. It is admitted by them. I will show that admission.
No,
Schedule
you have
page 30.
produced your deeds before the trial court.
Before the trial court.
Okay.
Now, 9.47 is the schedule, page number 30. 9.47 is the land which has the title, and 7.84, that is schedule 2, schedule 2 is the vested land. Page number 31. It is the vested land.
Whatever you have stated in the oral evidence, he has indicated that.
I will explain that.
First, explain that.
Yes. No, that's just before that I am showing something. The schedule. I will explain that.
I just tell you, if you are in legal possession of a land, what he has asserted, and in evidence also you say that you have no right, title, and interest unless the government issues a patta or vested whatever documents in your favor. Now, what is your position? Did your vendor, erstwhile vendor, had the right to transfer the land in your favor?
Yes, that I am saying. The entire land is, there is two parts. That is 9.87 and total is 17.52, 9.87 and 7. It is our specific pleading. 7.8 is a vested land. And what it is stated in the evidence, the fact.
Just tell me, what was the right of your vendor in over the land? Was it granted
on the portion of, there are two parts. I have to kindly give me a patience hearing, kindly. There are two parts. One in 9.47, he has the title. and 7.884, that is schedule 2, it is the vested land, he has the possession, and the tea garden is there, and it has been transferred, because maximum tea gardens are on lease fact here. The lease LOI is the lease document, LOI. Out of that, what is the case of the plaintiff? That is specific. It is the, now we came a civil revisional application. What he had argued is about the, it is best for argument for the title, I mean, appeal, but it is not an appeal. It is whether order 26/9 will be allowed or not. Now, what is the portion of the land which the plaintiff has stated that had been acquired by the, that has been dispossessed by the defendants? Kindly come to the page number 31, schedule has been stated. Last part, page number 31. Schedule of the land illegally occupied by the defendant number 1 to 9 as rank trespassers. This schedule is equivalent to the land that he has titled, that is 9.47 acres. In schedule 1, all the plots are there, not the vested land. Not the vested land that is stated in schedule 1-2. Schedule 2. Now, and defendant in their written statement admitted that in page number 36, admitted the plaintiff's possession, right title interest on 9.19. Page number 8, para number 8. Is the owner of 9.19 acres situated in Mojar, Khairkhal and Padamati. They had admitted it. They had disputed 5.71 acres, which is the vested land.
This 9.19 is part of 9.47.
Yes. He had admitted that they are, what they had stated here, that the answering defendants have gathered that the locus was the owner of 9.19 acres in Moja, Khairkhal and so, and the rest, and the defendants who have engaged in the plantation in the above Moja from long time had also known that the Lotus have unlawfully occupied this land, 5.71. So out of, there are two parts, 9.19 is the ownership, they had admitted, and 5.71 they had disputed as a vested.
What about the rest 3 point something?
Rest 3 point something they had not stated, they are silent, defendants are silent. We had stated that 9.47 is our written land and 7.84 is the vested land. It is our case. Schedule 1 is the written land and schedule 2 is the vested land. And what they had dispossessed our written land, that is from the 9.79 acres. It is 47 acres, it is our case. Now they cunningly stated a specific plots, they denied. What is the dispute now? They stated that they are possessing the vested land, but in different plots. Kindly come to the page number 39, written statement.
Yes.
They are stated specifically, these plots are in their possession. Last part. Moja Khairkhal, 1618, so and so, so and so, so and so. The description of the land in long and peaceful possession of SHG is this. And in 40, 3.66 and 2.1, total 6.25.
Hmm.
Now, so the dispute is what? The dispute is the identity with in which plot the actual disputed land lies, whether it lies on these plots that stated by the plaintiff or in this plot that's stated by the defendant. Whether it is retained land from the retained land or from that is the cost of the dispute. Now, if I go to the judgment of the Honorable Supreme Court in reported in that I have stated, the Sripath and Rajendra Prasad, it is stated clearly, in our opinion, the contention is correct. When there is a serious dispute as regards the identity, the court below, before decreeing the suit, should have got to the identity established by the issuing the survey commission to locate para 4, to locate the plot in dispute and find out whether it part from the part of Khosta so-and-so or Khosta so-and-so. So where the dispute lies, whether in this Khosta or this Khosta, or this plot or this plot.
Then you explain why did you then, in your evidence, you state that you have no title?
Yes, that I am stating. In the evidence, you have to read in total. In a part, he had read part. So it seems to be that. Now, if I come through from the front cross-examination.
What is LOI?
LOI is the given by the government when over a land.
Letter of intent.
Letter of intent. Given by the government for tea plantations.
Now, letter of intent gives a right to transfer the land.
No.
Letter of intent gives a right to a party to transfer the land.
He transferred the possession. It is a vested land. Part is the vested land. Total is not the letters of intent. Some part, that is 9.47, is the retained land. That is the deeds are there. And the vested part is letters of intent.
Now, what has been transferred to you? He has transferred the vested as well
as retained. Total 17 point. Now, the question that has been raised there, page number 61. Fact that the land measuring so-and-so in Moja, Khairkhal and Padumati is a compact land which was purchased to different deeds by Lotus Private Limited from the year Atu. The value of the property in the at that time was the nature of the property at that time was Shahori and Khash land. The Shahori is the retained land and Khash land is the vested. The fact that the Lotus Project Limited Lotus Private Limited purchased the surrounded the entire land property. Surrendered the entire landed property to the government of West Bengal by exercising the power under Section 14T of the West Bengal Land Reforms Act. Land Reforms Act, the government occupied the entire land and issued letters of intent in the year of 2000 to the Lotus Private Limited. After letters of intent was granted to the letter project, they started the plantation, tea plantation over the site. Fact that I have purchased the entire land in the year 2010 and 11, going through the letters of intent. I have applied for long-term lease. I have found the copy of some before the court. Then says I have not applied for entire long-term lease in respect of entire 23.70. The part there lies. The question they had put cunningly about the end part of the schedule, that is the vested land there in respect of the question they are going. But in that time they said that entire land, not entire land, it's specific, they're not 23 total land.
So
But
what you have stated in respect of the vested land.
vested land. That I have not paid the land revenue and says of the entire 23.70. The question is related to N23.70.
No, no.
Yes, the question is there, the answer.
34
I am coming. The evidence should be entirely, read entirely, not part. Fact that I have not paid the land revenue and says for the 23.70 acres to the appropriate authority. I am interested in taking a lease from the government after payment of the penalty for illegal occupation and statutory previous for that land. So all the respect is, question is all respect to that land, that vested land. Then comes, I have no document for right title interest over the suit land except LOI. Except LOI is the vested land, that is in letters of intent in respect of vested land. And suit land is total. So the mixture is that, the cunningness of putting the question is there. The fact that I am entitled to relief, I granted the lease. Yes, on the vested land, if I get the lease, but the dispute is not in respect of that land. Main dispute is in respect of the recovery of possession, that is in the retained land. That part has specifically stated in the schedule. In 9.4, it is admitted by the defendant in the written statement also. 9. So and so is the
That
ownership.
is the purchase land.
That is the purchase.
Now, why this 23.70? What is this then? 23.7061.
That is after that is 17 point something is ours, and 6 point is extra vested land which they have stated. So they had clubbed all the total and said 23 something. So question is cunning. Have to go through. So if it is not appeal, so I did not at the first stage I gone into detail. Since he gone into detail, I have to go to it. It is a revision only on the point of whether it will be a part of evidence of that, and thereafter it will be decided. That is the part. Since he gone into the detail and everything, tried to mix up and cloud the mind of the court, honorable court, so I have to go.
Complete.
So, as per judgment of the Supreme Court, since the main dispute is on that, where the disputed land lies, whether in this or that, it has to be determined. So, for the judgment in truth.
Complete. নিয়ে চলে যাবে হবে না learned advocates for the respective parties to conclude their argument. Hearing is concluded, judgment reserved.
Before Milord rises, Milord, Milord, yesterday I had troubled your lordship with a matter to move unlisted. Milord desired that.
On Tuesday, come on Tuesday.
Milord, Justice Sarkar has released it at 2 p.m.
On Tuesday, you mentioned there is a time for mentioning whenever you will come.
Request one thing, Your Lordship. Would Your Lordship take up MSCC application next Tuesday at the 12th?
It is in the second half after the civil revision, 3:30 I will take it up.
At 2 at least, Your Lordship.
2 no. 3:30 I have given time, 3:30 I will take.
So kindly take up, Your Lordship.
On Tuesday.
My lord, item number 17 in today's list. My lord, this has been wrongly listed in your lordship's bench, my lord. This is an application under Arbitration and Conciliation Act, my lord. It ought to have been listed before the court number 1. Section item number 17. That is the section 11 application.
Sure.